Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Me bring the jury.
Happy Fukong Friday, couch potatoes. It's our favorite day of the week. It's Fukong Friday. It never gets old. I love Fukong Friday. That usually means lots of fun, possible day drinking llama, which is also fun. So it's a win-win for everybody if Fukong Fridays are. Well, friends, today it's a Laura Owens day because, yes, we are covering lots of other stuff throughout the week, but Fridays are still Laura Owens day because it's Fukong Friday. And we are now at the point in 2024 where David Gingras has decided that he wants to be a YouTube content creator. How the tables have turned. As he spent all of that time writing all those motions about the pesky content creators making all their money and breadsticks and
he wants that
for clicks.
He wants that breadstick money.
So unfortunately, we don't have those videos, but what we do have is the transcripts to those videos. So that is what we'll be reading today in our best David Gingras impression, or however we want to read
our worst.
Because somebody went and got themselves banned on YouTube, which is kind of hard to do. There's not very many things that'll get you banned on YouTube, but apparently having a gun out will do that. That's the rumor I heard, that's why they got taken down. That'll do it. They do not like that. Other than that, I know some YouTube creators that I'm like, what? How are they still on? But yeah, not great. But before we get into all of that, hello, KD, with this was the first comment I saw when I got on. It was Laura is gonna be Owens. A lot of payback. Well played, Katie. Bravo to you. Bravo with the jokes. First thing in the morning. I love it. I love it. Good morning, Dan Montana and Echoes. Happy Fukong Friday. And I did listen to the beginning part of your video, and big hugs to you, buddy. All right. It's gonna be okay. Remember, everything is only temporary. Okay. Just keep that in your mind. All right. Everything, it's only temporary, even though it sucks. But hugs to you from us. And let's get together soon and do something. Are you guys going live tonight? Are you and G Daddy going live about anything? If so, hit me up because I'm available. Especially fun day drinking. Everybody knows. Just follow Llama all day long on YouTube. She'll be on somebody's stream at some point. Hello, Bruce the Moose. Good morning. Ahoy, good sir. Hope you're doing well. Hello, Mama Llama. Hope you're doing well today, too. RJ, hello, hello. Hope you're having a good day. Well, hey, hanging on is still hanging on, right? Violet Grace, is it Friday already? I know, it has been a crazy 2 weeks for me. I'm so happy it's Friday. Is it Labor Day weekend yet? As if I'm gonna take time off during that, but it's only the second day of school starting, and I'm already like, is it summer break yet? Are we there? Are we there yet? I'm over it.
You got a ways to go.
I have to.
Please don't wish that on us. That's harder for me.
I only have one, and so summer is just fine for us. We have a great time. But school, not so much. My not so little llama came back with his freshman year syllabuses for class, so I got to make a spreadsheet with them all this weekend to try to get us all on the same page of how things work because it's high school. So, and it's hard, and I'm not looking forward to it. I was like, oh, okay.
Your kid and my kid are not the same kid. If I just said something about a spreadsheet, she'd have looked at me and go, uh-huh. Pretty much how I looked at you whenever you talk about spreadsheets.
Okay, fine. Whatever makes you happy, girl. He's probably going to do the same thing because I got a lot of that yesterday when I was like, so how was your first day at school? It was good. Okay. Anything else? No. Okay. All right. Great talk.
That's standard.
Great talk. Okay.
Even my 7-year-old. What'd you do at school today? I don't know.
He's always been like that. And then he like gave me some papers to sign, and they were syllabuses, right, for one of his classes. And I was like, well, where's the other class syllabuses? And he was like, oh, but you don't have to sign those. I was like, I know I don't have to sign them, but what do they say? I need to know what they say. And then he didn't have like 3 of them for his classes. And he was like, I don't think they gave it to us. I don't think we're going to have one. And I was like, oh, buddy, you're going to have one. They kind of like have.
Oh, you're such a good mom. I'm like, all right. It's all on you.
Well, I'm doing my best. I might give up in like 2 weeks and just be in the corner crying. Like, I
Nope.
don't remember high school being so hard. I've been out too long.
I'm
but
like, 2 years, baby, and you're an adult and you're going to be responsible for all of your own actions. You better start now.
What if he took his violin today? He forgot it yesterday. I was like, oh, good Lord. Child. No, even their orchestra is very hard this year. Like they have like tests every Friday. I'm just like, oh my God, it's a lot to keep track of. A lot. So I'm gonna be spending a lot of time doing that, organizing our shows this weekend. It's a lot of planning and spreadsheets, which is my favorite way to spend a weekend. You should probably get your banana out of bed. Oh, hello. Good morning. Hey, Rob. Good morning. Hope you're doing well today. Yes, everybody be like Vil as you're coming in. Please hit the like button. Subscribe if you haven't. Hit the notification bell. Also, if you want to be a doll face, because we are streaming this on True Crime and Wine Time, but we're also streaming it on our new channel at Couch Court with Llama, which is where all of this is going to be moving to. All of this.
All of it.
All of it is going to be moving to as soon as we hit 500 subs, and we're close. So please go subscribe there so we can have memberships, fun little emojis in chat, super chats. I don't know when the jewel thing happens. Could be then. I don't know, but we're very close. So please go do us a favor and do that. Thank you very much. Oh, cute bun. Thanks. My hair, I was like, I don't have time to straighten it because it's a mess because of the humidity. Let me tell you what.
It's a much better bun than Laura's.
Yes, that's true. A bit of a top knot. A bit of a top knot. All right. Well, hello, 80s. Hello. Good morning to you. David Smith AZ is one of his YouTube alts. He used it to unlist video evidence for something in his bar case. Ooh, I did not know that. Look at that.
If you do a search on YouTube, there is a person that comes up, David Gingras, and it has a bunch of like saved music videos. And I was like, I wonder if that's him.
Is there Brittany?
Because
he
no,
loves
I didn't
Britney
go through
Spears.
it. I didn't actually go through it, but
he loves Brittany. So we'll know it's him if he has a whole Britney Spears playlist because he loves her. Hello, barbecue queen. Good morning. Same. All right. Well, we have
got a lot of 3 days grace in it, so
we have a lot of these YouTube videos because transcripts, because he went hard real quick. So the first one starts, I want to say it's 11/14/2024, and it's just like every other day, or sometimes more than one a day. He goes on there. What they say, don't know. Haven't read them all. We read one last week, which was fun. So let's go ahead and get started. We're going to take turns reading them in whatever way we feel like it. So sorry, David, you probably shouldn't have gotten kicked off of YouTube. Then we would have known how you really intended it, but it's fine. We're just here to have fun today. We're just 2 girls with microphones on YouTubes. That's all. So his first one, he's decided a name for his YouTube podcast. And he entitles it Grab My Pussy, Legal Podcast. Very, very classy, David. You should have stuck with the Britney Spears puns, okay? I appreciated those a lot more than this one. Hold on, let me put this on screen. Yeah, not great.
Why was he banned on YouTube?
Wouldn't know. Yikes. They're not going to like that in your title. I can tell you that. They're not going to like it. So, hello, Tanya. Good morning. Everybody scooch on the couch for Tanya. We are going to be here for a while. So, as I said, this is from like 11, I want to say 14, 2024, entitled Grab My Pussy Legal Podcast, Season 1, Episode 2, Transcripts. So, he doesn't complete and get to a Season 2. Just spoilers, everybody. How long does he even have this for? Like 2 months?
Like 2
maybe?
months.
Yikes. Yikes. I've seen crazy shit on YouTube, but okay. All right. So I'm going to do the first one. Buff will do the next one, and we're just going to rotate in and out. So I think it's just him on this one. I think we have one where Laura's on, but since it's just a transcript, I can't tell you when she talks or when he talks. I'm sure we can figure it out, but it's not laid out.
I'm
Somebody should have done
sure
that.
the chat knows.
I'm sure they do. All right. Let me get into my best David Gingras for today.
And I did
Gosh.
my very best not to pre-read these.
Yeah, I didn't pre-read these. And honestly, no matter how today goes, it has to be better than reading his 73-page appeal yesterday. Dear God.
Oh, no.
It broke our brains for the whole rest of the day. Buffy and I were just like, what?
I could not process any information.
It was awful. And for everyone
I
that
was
stayed with
asking
us,
questions about the appeal, and I was like, "So when is the trial?" And I'm like, "Oh wait, this is an appeal."
It's an
Like I
appeal.
literally just said it 5 minutes ago. Like my brain just broke.
Yeah, it was tough stuff. So everybody that stayed with us, you're the real ones, because it was rough, and I probably would have noped out myself. All right. Okay, guys. Hello and welcome to the second edition of the podcast with no name. It's not a podcast, I know. It's not a podcast. It's also not a blog. May not be a vlog. I don't know. I guess every channel has to have a name. I don't have one. I guess we can call it Grab 'em by the Pussy podcast. I don't know. I got a little bit of a theme going today in that regard. Everyone knows my stance on this stuff, but you got to be a little bit of a, you got to be able to take some humor at times. Speaking of which, there are some complaints about the production quality of my last video. Were you guys trolling him about his camera? There about the production quality of my last video. I have treated myself to, I don't know, they say it's a good one, Sony ZV-F1. Not using it right now because I'm just trying to figure it out. But I think the issue also is lighting. So I got some better lights, and I don't know. Do I look better? Mm, mm. I'm slightly less red, not that much to look at here. I got my hat on all day, so I'm not taking that off. Aurora and I are here at 4:15 on the 14th of November.
He sounds like he's
David.
leaving a voicemail.
I
Hi, this is
know.
David. It's 4:15 on the 15th of November.
Now Aurora is his cat, if you don't know, and she is a beautiful cat. We stand Aurora. We do, and I hope Aurora is doing well. And I love the name of his cat. Thank you, Rachel. It's my Stranger Things shirt. Thank you. That's the same camera you have, Bruce. Oh, he wants to be like you guys so bad.
Do you think he like tried to find out what camera you used? Like he was like, I need the same stuff.
Bruce, did you have your channel in 2024? What year did you start yours? 2024, 2025? I know you've been around for a little while, but I know you were behind the scenes for a while. So when did you start your channel, Bruce? You have to drink a whole bottle of wine to be on his level at the podcast. Don't worry, I got one in the fridge for later. His camera and audio, Echo says his camera and audio of the first couple of videos was terrible. Timeshare sales scams were better quality. Oh no. Well, he took it to heart and he took your guys' advice.
Wait, are you supposed to use a certain camera for like being on the YouTubes?
I think everybody uses different ones. Okay, you made videos before he did. Okay, I couldn't remember when your starting point was. I thought you said it was after. Did you say it was after the hearing, the Echard, or was it before? I try to remember everything. Turns out I can't. But all right, let's get back here. So it's November 14th. I was going to give you some good news today about the appeal being filed. It's filed. The opening brief was filed today. I
Oh.
tweeted about it. I tweeted about that I was going to give you some good news about the meeting that Laura and I had yesterday. We spent 2 hours shooting a video. We had questions and answers. She did take a JFC question, or at least, no, a submitted one, and answered it. And her answer kind of surprised me. And yes, there is a tag on my headset because I have 2 of them. That's how I know this one's mine. What? What are you saying, Dave? Would you leave the tags? Okay, all right. Who's the other one for? Oh, anyway,
Wait, why do you?
it's 2 headsets and one has a tag
Yes,
on it still. I don't know why you didn't get different
right.
colored ones or
First off,
whatever.
I don't think I've ever seen a headset with a tag, really. Not the ones I've seen.
No, mine came in a
2,
really cool
who
box.
who else is doing this with you
Must be
other
Laura.
than Laura? So Laura has her own. He won't even
Has
share it
her
with her.
own.
He's probably scared he's gonna get cooties.
Probably. I would be.
Or she'll get pregnant from using his.
Probably. He's like, no cross contamination with her. No, thank you. Is the other one for the
Never cross the
cat?
streams.
Maybe. Maybe it is for the cat. Maybe it's Aurora's headset. Oh my God, how adorable would
Oh,
that be?
that would be so cute.
People would
I
like
need
you more,
little
David.
doggy headsets.
June 23rd. Okay. All right. That's what I thought. I thought it was around that time, Bruce. Thank you for that. Hello, Say Cheese. Good morning. I'm trying to remember when they went to PS Creative for the Lost Unreleased Episode podcast thing. I don't know. I keep forgetting to put that on my thing. So, all right, where was I? So we got tags on the headset. Anyway, I thought yesterday was a good day. I felt I hadn't seen you, no, since the trial, June 10th. I had not seen Laura just one other time. I met with her and her mom. I don't know, in August or something to make a final decision on whether or not I was going to help with the appeal. And obviously, I agreed to do that. I hadn't seen her since then. And so we got together yesterday and I thought it was going to be a good day. It was a good day until it wasn't. And I have a rule about not talking about things or not, you know, if I get an email that makes me mad, I should not respond to it for 24 hours. That's true. You probably shouldn't, does he? I don't think so. That's been a rule for years. I don't know if everybody, I feel like a lot of people have the same kind of attitude of just sleep on it. Don't talk about things when you're mad. I don't want to talk about what happened with the podcast situation and JFC. Oh, is he talking about the PS Creative here? Maybe you got an email. Maybe that's it. I need to formulate my thoughts. And if you're watching this and if you're not happy with me for using the word cult, oh, is he talking to you, Bruce? Is he talking to you? I'm not talking about people that are interested in the case, and I'm not talking about people that are Clayton supporters, and I'm not talking about people that don't believe Laura. Who are you talking about then, David? That's like all of the people. Who are you talking about? I don't understand. November was when they went to PS Creative. Oh, so this would be yes. That's what he's upset about because this was
What is
November
PS
14th.
Creative?
It's that podcast studio. We haven't gotten to them yet. Well, I mean, it's in this part of the timeline, but we haven't covered their story yet, specifically. So we will get into that. It was a podcast studio they went to. There was some things going on. I don't know. I don't know enough about it because I haven't looked into it yet, but we will be covering that very soon as well.
Okay.
So, but it's a whole nother studio, a whole different incident because there's always incidences with these people.
No.
So he's not talking to anybody that is any of those things. So I don't know who he's talking to, but none of those things makes you a cult member. So if you fall into any of those categories, my apologies. I'm not referring to you as a cult member. The cult is the people that do this. This is, and this isn't even what made me mad, but this is a flyer that a cult member produced and sent to everybody at Laura's gym. Oh, the flyer. What did he already include that in something? Thought that's old news. Old news. And we know how YouTube feels about when you're covering old news. They don't like it. They'll let you know. Why aren't you
Needs to be
covering recent?
breaking. Needs to be immediate and emergent.
Exactly. Otherwise, don't bother. Anyway, let's see. Produced and sent to everybody at Laura's gym. This was weeks ago, maybe a month ago. Okay. Maybe 2 months ago. This wasn't even what made me that mad. Well, yeah, you just said it happened months ago, and this email happened yesterday. So, okay. And again, I'm not going to get into what made me mad or what I'm going to do about it. There will be something done about it, my friend. About it. My friend, Mark Randazza, uses the phrase crossing the Rubicon, which I'm not smart enough to know what that means. I think it means when your enemy does something so bad that it's time to declare war. I have not declared war on JFC yet. Oh, wow. Okay.
Oh.
All right. That's some choice words there, David, but okay. That time is probably around the corner. I've been trying to deal with this in the most professional way I can. Okay. I know that sometimes my tweets don't come across as professional. I'm 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 the first person to admit that. Okay? Sound sound like a dick when I write. That's why I'm going to try to use some video even though I'm not good at it. I'm practicing. Maybe my new camera will be amazing and it'll just be awesome. And Aurora and I can hear and look our best. Does everybody want to see? Oh, she's here and she's not fat. Okay. If you think this cat is fat, look in the mirror. Okay. Oh my gosh. Who's calling Aurora
Don't
fat?
fat shame, body shame my cat. Everybody loves a fat cat.
Exactly.
I only own fat cats.
So Aurora is a stray cat. She showed up. She's not a very friendly cat. She showed up in the backyard 5 years ago, and she just said, "I'm here, and you're feeding me," and that's all there is to it. Aurora is my spirit animal. Everybody, just to let you know. She happens to be, I think, a very attractive cat. David, what? All right. I
Wow.
think she's a good-looking cat.
I
Um,
told he talks in his blogs. Okay, vlogs, whatever, his videos, the way he writes, it's just a stream of consciousness. It's just whatever hits the brain, hits the page.
exactly. Um, she happens to, oh wait, I already read that. She's a good-looking cat. She's not warm and fuzzy. She does like her daddy, so she spends a lot of time with me. But anyway, we're not going to call it the Pussy Podcast or whatever. I'm going to come up with a better name. It's not a podcast. Whatever a channel, my video. Let's talk about some stuff that is relevant. I want, if I'm going to talk to you guys and if I'm going to take the time to do this, I want to add value. I want to share information that maybe you don't have, particularly because I don't think the other people who are giving you information are doing a very good job of telling the truth. Um, they disagree and they think I'm the epitome of evil in that department. But something in the appeal. Oh, so the brief, when you read it, and I'll share it when I need to share it. I think the best way to do this is, it's not really fair to Clayton, to be honest. If I release my brief first, his brief isn't written yet. So he doesn't he's got 40 days until at least Christmas Eve. Side note, pause the video. You remember when he said he wasn't a dick and wasn't going to file his brief, so they had to respond during the holidays? You said that, Dana. You said it in your blog. We read it. And then you went and you did the dick thing and filed it over the holidays. So, all right. Unpause. Back to this video. They have at least to Christmas Eve to submit it. I've already been in contact with the guy from Woodnick's firm. I don't think Woodnick does appeals himself. He has another guy that helps, and that's fine. There's nothing wrong with that. I've already told him, if you want to extend an extension of time, I will agree to that. There's no reason to work on stuff over the holidays. So I think he may want to, and he hasn't said that he wants an extension yet, but I think we're gonna probably bump out Clayton's deadline to early January. It would make sense. Then he has, not to worry about this over Christmas and Thanksgiving. And I don't have to worry about my reply, which I get 20 days to do. That I don't want to work on that over the holidays. So I think that just makes sense. We'll move it out. Court appeals don't care. We're obviously, a month early filing this thing. But when you read that brief again, one of the most important things I want people to understand is how appeals work. Right. You didn't need 76 pages though to say what you needed to say, but okay.
Does he ever?
Right. So this is not relitigation. Okay, this is not trial part two. This is not me asking the Court of Appeals. And by the way, the Court of Appeals means a three-judge panel. It will be three randomly selected judges from the Court of Appeals, and which I think they have about a dozen judges on the court. So they'll pick three of them, and those will be our judges. They will know nothing about our case. They will not have read or heard or seen anything about it. And, you know, they're human beings. Maybe they watch the little news. I don't know. Tucson's kind of a quiet place. So we are not going to ask them to relook at the evidence. And we're not going to ask them to say Laura was not pregnant or was pregnant. Clayton lied about everything. That's not how appeals work. You can't relitigate the facts of the case. And I've explained this to Laura as picture two different I use the metaphor of a baseball stadium. I don't know why. Two different buckets, two different cups. Okay. Here's one cup right here. So we got the Trump cup here. And over here, oh Jesus fucking Christ, David. Are you serious? Oh, this is so dumb. We're not getting into politics, everybody, okay? But of course, we should have known. All right, so I got the Trump cup over here, and over here is an imaginary Biden cup. It's imaginary because he's gone but let's say that the Trump cup is the facts of the case, okay? And the Biden cup is the law of facts of the case. Are things like was Laura pregnant? Was the sonogram real? Did she lie? Did Clayton lie? Blah 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 blah. Those are are facts. Those are the facts of the case. And Mata made factual findings. Those facts go into the fact cup. the law cup is things like which one's the law cup? Oh my god. Okay. The law cup is things like I guess it's this imaginary third one. How does this law apply to this? What is Rule 26, the sanctions rule? What does that require? Other rules that aren't Rule 26 can we you can't we use them here. How do they fit? Wouldn't it comply with everything that he needed to comply with? Those are legal issues in the Court of Appeals. Okay. We are not in this cup. I think this is the third cup. We are not in the
You
fact
hold it
cup.
like a ball sack.
The-
But you're
That's right. Oh,
you're just like
no. No.
we're cupping them.
This is the imaginary cup down here.
Oh man, did I just say that out loud?
Gap, you did. Thanks for bringing that to everybody's attention. Can't wait for Savage to clip that. Um, so let's see, where were we at? There's the imaginary cup. I lost my spot. Okay, we'll go back here. So we can use them. How do they fit? Wouldn't it comply with everything that he needed to comply with? Those are legal issues in the Court of Appeals. We are not in this cup. We are not in the fact cup. We cannot ask the Court of Appeals to change the factual rulings unless, and there's only one exception, if MATA made a factual finding, for example. We do have one. Planned Parenthood was closed on Sunday. There's no evidence in the record to support that. And the only facts that can, or the only factual findings that are supportable, are those that have evidence admitted at trial to support them. Evidence is testimony of witnesses, admitted trial exhibits. Arguments of counsel are not in is not evidence briefs, not evidence. You have to have evidence to submit every fact or to support every fact. There are facts in modest findings, as we know, that are not supported by any admitted evidence at all. We are arguing about that. I had raised that that's my second argument in the appeal. But what I want to emphasize is that you cannot relitigate the facts. What about the cups, David? Why did we even have the cups? It didn't even make any sense. We weren't pouring things from different cups. Why? We didn't even need that.
He just wanted anybody who retold this story to cup.
Fell for it, David. Fell for it. It's fine.
You're telling me he didn't relitigate anything in that appeal?
Right, the whole thing was as if he was. But okay. Okay. Sorry, I'm thirsty from all the cupping. All right, where was I? Blah, 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 blah. His second argument in the appeal. But what I want to emphasize is that you cannot relitigate the facts. So I cannot, and I also cannot introduce new evidence. The only evidence we're going to use is something called the index of record. This is it. Just looks like a docket printed out because that's pretty much what it is. The Court of Appeals does not allow anything that's not already on the list. So I can't, for example, I can't use this because this isn't on the list. This happened after the trial. I can't use tweets. I can't use Clayton's podcast or all the interviews he's done since trial. But wait, pause this video, pause David's imaginary video. But didn't he use as his argument about the Sunday abortion clinic thing from his own blog and the tweets that happened after?
I'm so
trial?
glad you asked that because I was just thinking the same thing. I was like, but didn't that stuff that was on his blog that he used in the appeal came after the trial, not like before?
Yeah.
Also, apparently Laura wasn't taking notes because that appeal she tried to have with Michael Maricini recently, she tried to introduce new facts and
Idiot.
stuff in her DVRO appeal, which is so funny. So
Which, I mean, he's not wrong. This is how appeals work, right? You can't bring any like new evidence, nothing like that. A lot of people, I mean, we don't really A lot of people don't get into the appeal stuff because it seems kind of boring and pedantic. I
like
enjoy
appeals.
it. I do too.
And I absolutely love appeal hearings.
I don't love his appeal. I'll tell you that. Yesterday was the worst day. It's not a fun day, David. It's not fun. You broke me in puppy.
No, I like reading appeals because I like when they just fire. I mean, because you only have so much space and you have to like make your strongest arguments, and usually they get really into it, but they don't spend so much time on one thing.
Rule 26.
Yeah.
Have you heard of
Rule
that before?
26. Never heard of it. First day was
Never heard of
yesterday.
it? Oh, okay.
And then I do like to watch the hearings where the judges fire off a billion questions. It's like rapid fire responses. I think it's freaking fascinating, but
I love it. I love appeals hearings. All right, so back to his video. This is only at 9 minutes, this video. Okay. I can't use it. That rule applies to me. It applies to Clayton. So the only facts we're going to talk about are the facts that you've already heard. So don't expect bombshells. Don't expect new sonograms. Don't expect, surprise witnesses. Don't expect, people, 6 other victims to come forward.
Sir, our
Nobody's
expectations are very low of you.
Just at the bottom. At the bottom. We have none, quite frankly. Let's see. Other victims to come forward. Are they on the list? No, they're not. Okay. So they don't exist. So don't expect the new facts to come into the case in the Court of Appeals. Also, don't expect arguments you haven't heard before. I know what's going to happen when you get the brief. The JFC YouTubers are going to sit and read it, and they're going to say, oh, Gingras, what a loser. He's just bringing up the same old stuff he's already argued in front of Mata.
So he is self-aware.
He is, yes. And he lost once, and he's just going to lose again. Guys, that is what an appeal is. You can't raise arguments for the first time on appeal with very, very limited exceptions. You can raise some subject matter jurisdiction and other things. But most of the time, a legal argument cannot be raised for the first time on appeal. Like, pause the Jingy YouTube video. We know, David, but it was also so repetitive of your point over. It wasn't good. And I didn't like it.
No.
Not an appellate judge, but didn't love it at all.
And it just goes to show that we were right, that he didn't write this for the appeal judges. He wrote this for JFC because he had very much in mind what JFC was going to say while he was writing it.
Exactly. He sure did. He loves you guys. He really likes you guys. I think so. Oh, farts. Where did I go? Issue. I wrote,
Sorry, I quit interrupting. I have ADD and it won't allow me to hold it or I'll forget it.
Oh, here we are. We're back up at the top. For some reason, I thought we were at the bottom. No wonder I couldn't find it. He's going to lose again. You can't raise arguments for the first time on appeal. Okay. He's just going to lose again. Guys, this is what an appeal is. You can't raise arguments for the first time on appeal with very, very limited exceptions. You can raise subject matter jurisdiction and other things, but most of the time, a legal argument cannot be raised for the first time on appeal. And if you look at the rules of civil appellate procedure, when you talk about what the brief has to contain, the very first thing the Court of Appeals wants you to do when you reach each issue in the brief that you're talking about, you have to point them page and line. Where did you raise this issue before? If you can't point to a place where you raised an argument before, you don't get to raise it on appeal. So I'm just emphasizing the fact that when you get to read my brief, if the arguments look familiar, that's because they have to be. There's no other way to argue things other than to say, hey, I already brought this up to the trial judge and she got it wrong. So that's just so that just understand when you read my brief, look at it from that perspective. Also, look at it from the perspective of I wrote this for 3 judges who have never heard of this case. They don't know anything about the facts. They will not have read everything in the record. This is thousands of pages long. What what all of these documents, it's every pleading, everything that has ever been filed in the trial court is in the record. They don't have time to sit and read all of that. I'm going to go with shit. My job is as a lawyer to basically be a tour guide for them. So see, David, you should do the travel videos. So I'm, of course, going to point out all of the things along the tour that I think I pointed out some things I don't like, but I think I need to know about what I'm about. I'm not trying to, pull one over on anybody. Clayton's counsel, I'm sure they will come forward and do a very good job of pointing out all of the things they think the Court of Appeals needs to know. I could actually probably tell you, and I don't have the time. Aurora is going to need some dinner soon, so I could probably write their brief for them. I can predict exactly what they're going to say. And, it's going to be, I think it's going to be this. I think they're going to focus on the facts. I don't think they're going to talk a lot about the law because the law, they're absolutely, I don't know. I don't mean to be rude, but there's no law to help them at. Oh, all the facts there. He must have said something very derogatory because all the facts. Yeah, there's some facts that are good for them. I never said there weren't. I never said that Laura was perfect. I never said that every single aspect of the case was 100% in our favor. It's not. No cases like that. And obviously, Mata, okay, we're going to segue into that it is possible. And look, as I get down this next sort of line of thinking, I will stop. He said he was going to be done and he just keeps on going. I will stop and say that there is a rule of professional conduct that I am bound by that says I'm not allowed to make a knowingly false statement imping the integrity of a judge. I am about to make some statements that impugn the integrity of a judge. Oh, David, don't do it. Don't do it. It's a bad idea. I, first of all, do not know any of them to be false. I believe them to be factual. I also am stating some opinions about things, and I want to be very, very clear about what's opinion and what's facts. So, the facts that we know are, and these are not news, and they are mentioned in the appeal, is the Planned Parenthood uh, closed on Sunday thing. I believe and have accused accused Judge Mata of violating the U.S. Constitution, the Code of Judicial Conduct, variety of different rules that say you can't do that. There are rules that limit when you are a fact finder, and in a bench trial, the judge is a fact finder. In a jury trial, the jury is a fact finder. And if you've ever served on a jury trial, you know the judge will tell you you can't go do independent research. Don't go look at Google. You can't look things up. You can't do that because it's a violation of the basic rules of fairness. Because if you go do that behind the scenes, the other parties don't know what you looked at. You may have looked at something on Google and it's not true. You can't do it behind the scenes because it's not fair to both parties who have a right to know. What did you look at? Is it true? Our job is to find it out, ferret out the truth, whatever. And sometimes the truth is out there. Do, 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 do. The truth is out like X Files.
Trust no one.
And sometimes it's not accurate. And anyway, you can't do that kind of investigation. I believe that Mata did do that kind of investigation. I explained why in my pleadings. I don't need to go back over that too much. But one thing I do want to share that people may not know is when I got back from my cruise, I was on the boat until the end of June. I got back, I immediately, at that point, the bomb had already gone off as far as had ruled against us. There was a thinking on the cruise when I first heard about the dad being at court. That's all I knew. I didn't have the ruling from the judge yet. So I didn't know that about the closed on Sunday thing. All I knew was her dad being there. There was some thinking on that cruise, like we should file a notice of change of judge and try get a different judge before Judge Mana had a chance. I was suspicious and I was worried when I found out about the dad being there. It was sort of the last in a chain of events that began with her rulings on things that were really, really not normal in my experience. For her to deny a request for an extension of time, the very first thing I filed was a request to for more time to respond to Woodnick's motion to compel. We know it was 39 pages asking for more time. Stupid, David. Stupid. I didn't have the file from the other lawyer. I had just gotten on the case. I literally filed that motion, I think the day I was hired. We know it shows it was just your stream of consciousness for 30 something pages. No other judge I've ever been in front of would have denied a request like that. And Judge Mata did without explanation. And the result of that was, unfairly favorable to Clayton and Woodnick, unfairly prejudicial to Laura. And there were other rulings down the way where Mata did things that looked to me like they indicated bias. And that's if a judge is biased, they're not allowed to be on your case. Unfortunately, you can't argue bias based on the judge's rule against me. That's not how the everybody would in every single case would say, "Oh, I lost, so the judge must not be fair." Every single person does that when it's the case, though. Like everybody does that. We know that. But you can't do that. I respect the rule. That's why I didn't do anything about it at the time on the cruise. We thought once we found out the dad was there, I'd say that's kind of the last straw. I think we have enough at this point to do something. I then sent an email to the judge's clerk. I asked her whether the dad was there and whether the statements about her talking to him about the case were accurate. Instead of denying that, Judge Mana said, file a motion, okay? And then 11, 12 hours later, she rules against us. So I get back from the cruise and then we have a ruling. Then we have the time to go through and find, hang on a minute. And Laura initially thought that she reached out to me and she said, "Holy shit, Mana copied all this from JFC." And I said, "What do you mean?" And she said, "Well, look at this timeline. Look at all these facts that this is straight copied off justiceforclayton.com." And I went there and she was kind of right. Most of it, a lot of it, almost word for word, but not entirely. And, the timeline on JFC is not, I don't think it's necessarily wrong in terms of the events and so forth. The content I don't agree with, but that was my initial red flag. To hang on a minute is the judge basing her rulings on JFC's website, which was not offered into evidence, was would not be a basis for her to rule on anything. But I'm not comfortable because when I started to look at it, I submitted a very detailed proposed findings of fact and conclusions of law. We read it where I explained the timeline the judge could have used. That timeline, I think she did use the timeline I gave her. That's why you do that sort of thing. You give the judge, you basically try and do the judge's homework for them. That is totally proper. It's something lawyers routinely do. You're you're just telling them, here's what the evidence is about to show you. And then, they hear the evidence and then they look back at your timeline and they say, oh, yeah, you were right. Okay, so you've done my homework for me. I'll just use that. I could not argue anything about Mata doing independent research unless I could confirm that the information in her findings could not have come from anywhere but outside of the pleadings or outside the evidence. And because I submitted the detailed findings of facts, conclusions of law, and my findings of facts kind of match the JFC timeline. Uh, did she get her timeline from JFC? Did she get it from me? You can't tell. So I couldn't raise that issue. But the closed on Sunday thing, when we finally saw that, I then panicked and thought, Jesus effing Christmas. I was not on this case from the beginning. What if it was raised somewhere else? My office phone is ringing, and thanks a lot. Do I edit? No. I'm just going to hang up on them. Yeah, Aurora, I know. So anyway, I was worried that the issue of Planned Parenthood's business hours, what if it was mentioned at a prior hearing that I wasn't at? What if it came up in some other, pleading that I didn't read because it was before my time? Oh man, I can't believe he's still saying that. Or what if there's an email between Corey and Woodnick talking about that issue? So I had to go back over the entire file with a fine tooth comb. She probably should have done in the first place, but okay. Me, Laura, and my wife, who works with me. So she's kind of my illegal. I don't think that's the transcripts on YouTube's are not perfect. Okay. So we all separately went over more than 1,000 pages of pleadings from the file to try to figure out, was the Planned Parenthood on Sunday thing mentioned anywhere else? And it was not. And if you think about it, there's a good explanation for why there wasn't any discussion about it, because Laura never said she went to Los Angeles. How is this going to help your case? Sure. Okay. Until the minute of trial. So she was sitting on the stand. It was always Orange County, right? Orange County's open on Sunday. So why the hell would anybody care about their business hours on Sunday? They're open. In that it never became relevant until the minute she was on the stand and changed her story. And we're going to get to that, not today. Um, but that was when Sunday became an issue. And that's why prior to trial and everything in the file there was never the word Sunday mentioned, not once. So when I found that out, I then filed a complaint in addition to. So I filed a notice of change of judge for cause. I filed a motion for a new trial. I also filed a complaint with the Judicial Conduct Commission. I'm not going to share that what they do is confidential. If you look at the Judicial Conduct Commission rules, they have been criticized for being a bit too secretive. They do not have a docket. You cannot call them. You're welcome to try. What they will tell you is there is a complaint pending against Judge Mata. Here is the case number right there. Case number 2, 2024-265. So this is their letter back to me acknowledging the complaint. It's kind of crazy that it's all secretive. I mean, the bar is kind of too, but bar complaints, but also I do feel like they should be a little bit more transparent. A lot of judges are elected officials, so in many places. Anyway, where was I? Before this, I think it was, oh, okay. So I filed the complaint about a week before this. I think it was the 9th of July. And they wrote me back to me and have confirmed the complaint that there has been some additional discussions with, well, not discussions, but some additional correspondence with them. And I'll get to that in a minute. This is where I'm going to tell you some speculation. These are not facts. I'm giving you my opinions based on what I've just explained. I filed the notice of change of judge, filed the request for a new trial, so on and so forth. And I filed the complaint with the Judicial Conduct Commission. Mata then denied Laura's motion for a new trial, while her notice of CH, the notice of change of judge, was pending. She had no authority to do that. You've probably seen some discussion about that. When you file a notice of change of judge, the rule basically says, and case law interpreting the rule says, the judge that you're trying to get rid of is essentially sidelined. They can rule on emergency matters only, but other than that, they are supposed to touch the case. They're not supposed to touch the case in any way, shape, or form until the notice of change of judge is resolved. Makes perfect sense. Judge Mata violated that rule. And she ruled on the notice of change of judge, or I'm sorry, she ruled on the motion for a new trial. And by denying it, a week or so after, I filed this complaint. And there's a rule that when you file a complaint against a judge, they are not allowed to retaliate against you. One of the examples of retaliation is they are not allowed to file a frivolous bar complaint. The rule doesn't specifically say they can't deny motions that they have no authority over, but Mata did the day I got her ruling, so that I contacted the Judicial Conduct Commission and reported a violation of the retaliation rule, or what appeared to be a violation of the rule. Um, I felt and still feel that what happened is Judge Mata ruled against us on the motion for a new trial as a form of retaliation for this complaint. David, that is not why. No way, sir. If that's true, it's a separate violation of that. Well, it's a violation of the judicial commission rules. It would probably be separate grounds. I mean, Mata, I said, I'm accusing her of a specific violation of the Code of Judicial Conduct based on her independent investigation and based on her talking to her father. If along the way, she also retaliated against me in violation of commission rules, that could be an aggravating factor. If they decide to punish her anyway, that would happen as I contacted the commission the day I got her order, denying our new trial motion. And then the very next day, Mata issues a new order withdrawing her prior ruling, saying, oops, I did not know about the notice of change of judge, which is not a credible thing to claim when the motion for a new trial on page 1 said there's a notice of pending notice of change of judge. Is this the same? Why are you saying the same things over and over again? Jesus Christ. So I don't know who's going to rule on this, but Mata claims she ruled on that motion without knowing that there was any way I think it was retaliation. I do not know for a fact. It is possible that it's just a coincidence. When she withdrew the prior dismissal or denial thing, I think the date was before I contacted the Judicial Conduct Commission. So if that date is accurate, which is not the date that it was filed with the court clerk stamps it and it has the court clerk's date. That date was after I contacted the commission to report the retaliation. The date on the order is before that. So she either issued that order before I reported the retaliation or possibly put a date on that order that's not accurate. Now that's not a fact. I do not know that. That is it's just pure speculation. I don't know. I'd like to know. I'd like to dig into that more if that happened. Anyway, let's not go further down that. That is not a statement of fact. That is my opinion. But here's another fact. On September 17th, 2024, so about 2 months ago now, Judge Mata filed a bar complaint against me. I have it here. Yep, September 17th. Why do you think that our trial was June 10th? September 17th is over 3 months later. Uh, why do you think that she waited more than 3 months to report me to the bar? Could it be because of this? I don't know. Again, I don't know. To me, it looks like retaliation. I have, by the way, reported a second act of retaliation to the Judicial Conduct Commission. Oh, shit, David, Jesus. And what I will tell you as a factual matter, again, everything they do is secret. I can't tell you what the status is. They may very well have dismissed my complaint. The complaint is primarily, like I said, it's based on things you already know. Oh my God, why are we going to talk about this again, David? Why? There's nothing. I didn't put in the complaint anything more than what I've already put in the pleadings, as far as the notice of change of judge and stuff. But although the conduct of the Judicial Conduct Commission is secret, in case you didn't know that, pause the video. In case you didn't know, he's told you this 1,000 times already because he thinks everybody's dumb, or he just repeats himself in a loop every 2 minutes, saying the same thing. Because I'm the complaining party, I have the right to know how my complaint was resolved. When they conclude the case, they will not. They will let me know, hey, we dismissed it, or we didn't dismiss it. As of November 14th, 2024, they have not notified me that they have dismissed it. Now, it may very well be that they are beyond busy. They may have not even looked at my complaint yet. They may have done nothing whatsoever. And they may wind up in a month or 2 or 3 sending me a letter saying, Gingras, we looked at your complaint. Go screw yourself. She did nothing wrong. That has not happened yet, but other things do happen for him. So I think that means, and I said I reported her retaliation. Her parents' acts of retaliation twice to the commission, and they did respond. And I asked the second time, I said, can you give me a status report? And they said, no, we cannot. Uh, they said, we're adding this information to the file, is what they said. I think that implies that they are taking the complaint seriously. And I think with good reason, because I believe that what I claimed happened. I believe that Judge Mata went online, and I don't. Again, this is speculation. I think it happened in February. I think when you look at the docket prior to February, things look pretty normal. She didn't do anything that was terribly weird prior to, wouldn't getting involved, moving for sanctions, raising these red flags or alarms, and saying, Judge, we have a pregnancy faker. After that in February, and you'll read this in my appeal brief because I go through the entire timeline. Things get really weird in terms of what Mana did. How did she? How she did it? She granted a motion, Laura's motion to dismiss the case. She granted that twice. A month goes by, and then she changes her mind and ungrants it. She said that the issue of sanctions was moot, and then she granted sanctions that she had just said were moot. Um, there are things I've never seen anything like this. And again, I don't mean to channel Mr. Trump, you know, you've never seen anything like this before. What does that have to do with anything, David? I have litigated hundreds of cases. I have never seen anything like this. And maybe it's just a family court thing. Maybe family court, it is a different ballgame. I've had trials in family court before in my career. I know that they are different in terms of half of the people in family court don't have lawyers. And it is very, very normal in family court for judges to use a less formal approach to things. The family law rules even say you don't have to follow the rules unless somebody invokes them, which Laura did. One of the first things her prior lawyer did was to say we were following all the rules. But I think my personal belief is that at some point in February, Mana started looking at something. She started going online. It's a human thing to do. I'm not. I don't even have a problem with it, to be honest with you. Uh, that's not the issue. The issue is if you go outside of the evidence in court and you allow information that may or may not be accurate, if you allow that information to affect your thinking, you at that point, you're not a judge anymore. You're an advocate. You're not doing what the county and the people in Maricopa County are paying you to do, which is decide cases based on the evidence that you get in court. And that's it. So I don't know again. I do not know this. I do not. I could be completely wrong. And by the way, I'm going to say something else. It is entirely possible that Judge Mana has done nothing wrong. It is entirely possible. Well, it's possible that a member of her staff did this. It is possible that a clerk went on JFC and found the thing, or found the closed on Sunday thing, and that Mana herself isn't the one that did that. I don't know. I don't think that's likely because of the other apparent conduct that I've seen from her. Her denying my request for a pretrial conference when the law required her to set one up upon request. I agree. That was weird that she didn't give him a hearing. I do feel like he should have been entitled to one as a new lawyer, but with only like 2 months before the hearing. But whatever. What do I know? Her refusing to honor the California domestic violence restraining order that Laura had against Maricini. Mata did things I just cannot explain by any other reason besides bias. Uh, it it's just not normal judicial conduct from my experience, but it could have been. I could be wrong. I could be wrong. It could have been a clerk that did it under the rules. That doesn't matter. Misconduct by judicial staff is basically imputed to the judge. It wouldn't change any part of the legal arguments on appeal. We would still be entitled to a new trial. And Mona could probably defend the Judicial Conduct Commission. She could say, well, I'm throwing my clerk under the bus. They're the ones who did it. She would still get in trouble because it's her court, it's her job to make sure everyone's playing by the rules. If a clerk broke the rules, that would still fall on her shoulders. Would be a lesser kind of violation than if she did it. But the interesting thing to me, and I told this to the state bar, and I'll read this to y'all. I'll share. There's nothing in here that's new. There were 4 points. What did she say? The waving of my hands. I don't know what that's about. She said she was coaching. Oh, when he was waving his hands to Laura, that she said was coaching. Well, which I'm gonna respond to that. I have responded to the bar, by the way, at length and in detail. And I asked the bar, by the way, to not only dismiss this, but to also report separately to the Judicial Conduct Commission that they find this complaint to be frivolous, which would mean it's another violation of the Judicial Conduct Commission rules, and could warrant additional sort of sanctions against her. Um, my belief is that at this point, because the commission hasn't dismissed it yet, I'm guessing that they have contacted her and asked her to respond. And she has a right to respond. It's kind of I'm not an expert in this. I've never filed a complaint against a judge in my entire life. I have gone on the commission website and you can see what they do in other cases because when a judge is punished, they will put the file online. Oh, I did not know that. That's pretty interesting. So you can see how it works. I'm guessing that by now they have asked her to respond and that she has done so. I would be fascinated. Can you imagine if her response was, and this would be the ethical thing to do, if this is true, imagine she responds and says, "Yeah, Gingras is right. I went online, I looked at some stuff. I think I just got carried away." Imagine that she said that. If she said that would guarantee Laura the right to a new trial, guarantee. And we're not asking my primary argument in the appeal is not for a new trial. That's an alternative relief. We're asking for the primary relief that we're asking for is to dismiss the entire case, throw the judgment out, and Laura walks. That's the relief we're asking for as a fallback to that. We'll ask for a new trial. We have asked for a new trial, but this issue of Mata, did she do it? Did she not do it? The Judicial Conduct Commission, I think, has information that would be helpful to that. And I would like to have it. I'm not entitled to it yet. We're going to get to that point. For now, I'm just going to sit back and let them do their thing. And this is not personal. I'm not angry at Judge Mata for how she ruled. I've had other trials that I've lost. I don't ever get mad at a judge who is fair. I serve as a judge from time I served as an arbitrator. Um, I'm not in two capacities. Number one, I work for the state bar as unpaid volunteer free arbitrator. Really? Has he chat? Has he ever? uh, That's interesting. But the state bar is a program where if a lawyer and client have an argument about fees, they can go to the state bar. The state bar will assign an arbitrator, and the arbitrator has basically a hearing, a trial, and then decides whether the lawyer's fees were reasonable or not reasonable. I've been doing that for several years now. As again, it's a volunteer thing. You sign up for it, you have to go through training. But when I'm an arbitrator for the bar, I go down to the bar headquarters, I sit in a conference room, and I have a trial. And I'm the judge. I listen to evidence and I decide who wins. And I have the ability to kind of mess up people's lives. That's a weird thing to say, David. I have the ability to say that a lawyer charged a fee that they shouldn't have. They could theoretically get in trouble for that. I have the ability to order lawyers to repay money if they've been overpaid. I also work as an arbitrator for the Superior Court, as do all lawyers in Maricopa County who've been practicing for over 5 years. You get basically drafted. You have to, once in a while, the court clerk sends a notice and says, "Hey, Gingras, you're an arbitrator today." And they will give me a case, and I will be responsible for basically acting as a judge. Again, I hold trials. I have witnesses come and testify. I make rulings, and I decide who wins and who loses. And I've done that multiple times. And I may even share some of my rulings. I write like 20-page complicated rulings explaining who wins and who loses and why. Because I care about people trusting the courts. I want them to think that the court system is fair. And I don't. I'm not. I get when I do the superior court arbitration, I get paid $75 for the entire thing. And it often takes me weeks of time. I don't care about the money. I care about, it's a privilege to have that power to affect someone's life by, serving as an arbitrator, finding in favor of one party and against another, and then awarding money. Um, I view that as an unbelievable responsibility, and it's something I take incredibly seriously when I do it. Um, I don't think Mana took that seriously in this case. To have your dad there, not against any rule to have your sister follow Clayton on Instagram, not against any rule to favor one party and rule in favor of that party on every single issue, every single time, because they were on a TV show. That's not a judge. That is not what we have judges for. Is that what happened here? That's my opinion. That's my personal opinion based on the facts that I've explained. In that opinion, could be wrong. I would love Judge Mata. There's nothing preventing Judge Mata from issuing an order right now. She could do it tomorrow. Issue an order and say, there's been a conflict regarding whether or not I researched something. I'm informing the parties. I did not, my clerk did, or some other explanation. Whatever it is. Mata could do that tomorrow. Um, she did not, by the way, in her bar complaint, unbelievably, she did not accuse me of making a false claim against her. She actually said the opposite. She said that she talks about the notice of change of judge, which is where I accused her of misconduct. And she says the court takes no issue with the notice, meaning she does not challenge. She did not challenge to the bar what I said in my notice of change of judge. She did quote, I'll just show you the quote. Can we focus? Mr. Gingras was unprofessional and inappropriately disparaging within his pleading. For example, look, Judge, I'm a real daddy. Or I think that's wrong. Judge, I'm daddy. Look, Judge, I'm a real daddy now. Look, Alora, I'm a real cat now. So she didn't like that. I don't blame her for not liking that. I didn't think it when I wrote it. I stand by it 10,000%. And I would write the same thing a million times until the end of time. Oh, wow. Okay. I did not mean to insult her, but I'd keep doing it. I meant to criticize her actions by describing and a pleading that was not for Mata to decide, that one to her boss. What I was trying to do was convey how Judge Mata's actions made Laura and I feel that day we felt I don't want to say humiliated isn't the right word. We felt that Mata was putting on a show, that a circus, that she was trying to be a ringmaster, putting on a circus for entertainment purposes only. And I cannot tell you how angry that makes me. She put my physical safety at risk. I had a gun. I brought a gun with me to court, not into the building. You're not allowed to do that. Arizona is open carry state. You can have a gun anywhere you want. It was in the car. I had private security with me, which I had court security because we were afraid that some lunatic JFC cult member was going to run up to us and blow our heads off. And Judge Mata put us in that position when there was nothing for the court to decide. There was no motion for sanctions because that had been withdrawn. And there was Laura had moved to withdraw her paternity petition. So there was no paternity issue to decide. The only reason that we were there was as entertainment. And I cannot tell you how angry that makes me. Um, God forbid something had happened that day. Um, I just I just if it doesn't make you angry, I don't care what you think about Laura. I don't care what you think about me. If you were put in that position where a judge put you on parade for her dad, um, yeah, it's enough. It's enough. I'm going to go forward with our appeal. I'm going to basically guarantee you a win. Are we going to, walk away with the courts? Not going to say that Laura was pregnant and told the truth and that Clayton lied, the court appeal is not going to do that. What they are going to do is, I think they're going to agree with me on the law. They're going to say that Clayton has no right to continue the case after Laura moved to dismiss. They're going to order the case to be dismissed. They're going to vacate the judgment against Clayton. And I think they will probably order Clayton to pay Laura's fees. And when with that request goes to 650 an hour for Clayton or for Woodnick, yeah, I'll put a bigger number out there. So hopefully the Patreon and the GoFundMe are, you are rolling and filling with money. Because Clayton, you're gonna need it. And when this judgment is vacated and set aside, and the whole thing dismissed at that point, Laura will have the option of pursuing litigation against everyone that has harmed her. And what what that's going to look like, and who that is going to involve. Yeah, we'll wait and see, and we'll cross that Rubicon when we come to it. But that's my prediction. In the meantime, I really, 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 really hope that the Judicial Conduct Commission does their job and takes this seriously. Judge Mata should not be on the bench. She is not fit for that job. And one of the reasons that I think that, if you look on, I know people have talked about the robing room. There's complaints about her on the robing room, and some JFC, who knows what he called you, have gone on there and put fake positive reviews for Judge Mata. You are going, you are doing that. How dare you go online? People count on this, people who live in Maricopa County. Need to know, hey, I've got a judge and I don't know whether this judge is good or not. I'm going to go on the robing room and look at the review, because there's not many judge review websites. And JFC lie and praise Judge Mata, and people who have children, custody disputes, are going to go and look up Judge Mata because that's their judge. And oh, look at all these positive reviews. I guess I'll let her handle my case. There's another person on the robing room before I was involved who submitted a complaint about Mata, using Google to research a snake that a mom had a pet snake, and the dad was fighting her for custody. And the person claims that Mata said at a hearing, "Oh, yeah, I Googled your snake to see if it was like appropriate for the child to be around." And then Mata took the child away from her parent based on her Google research. Sound familiar? Yeah, I agree. Aurora, ugh, it's enough. Oh, okay, we're going to sign off. I probably, I don't know what I need. Need a volume or something. I don't like to be angry. And I'm not normally angry. I'm not, and I'm not angry about this. And outside of the context of, Laura is not a bad person, and the people who think that she is, I don't know what's wrong with you, Clayton. I don't know what's wrong with you, bro. Uh, I've been in your shoes, and I cannot understand what's going through your head. Um, to torture a young lady like this, even if it's everything that you're saying is right about her, how how couldn't it how you couldn't be a bigger man and just let her be? I don't know, man. It's, you're different from me, and that's weird because a lot of people rightly criticize me for being, I'm going to go with asshole. We're just going to put asshole in there. Up in the past, I'm not asshole up anymore. Oh, probably fuck up. I bet it's a fuck up. Yeah. Criticize me for being a fuck up in the past. I'm not a fuck up anymore. I'm a good guy now. I am. And I'm going to make sure that Laura gets every, ounce of justice that she deserves from this case. I'm going to make sure that anybody that broke the laws is held accountable. That includes me. Oh boy, David. Oh boy. If I did something wrong, bar complaint me all day long. I don't care. Um, I'm playing by the rules, folks. I know you don't think so because I'm mean tweeting. I'm sorry about that. I think this format's better. Do you agree? I find it easier. I guess 42 minutes into this so far. I'm still not great at this, video thing. It's awkward to me, but I'm going to get better at it, and hopefully this little guy will help. I don't know if it's not the right camera. I'll get the one that is I'm not trying to be a blogger. I'm not trying to be a vlogger. I'm not trying to be a YouTuber. That's not my jam. I'm good at law. I care about law. And so I'm going to stick with that for now. And I really look forward to this case ending someday. Unfortunately, it's not going to end any time before the spring. So Clayton's brief will be due, I hope, early January. We get 20 days for our reply. I'm going to ask for an oral argument. We'll have that. The court will probably grant that. So we'll argue the case sometime in February, March, April, and then get a decision a few months, into the summer sometime. And I think they're going to crucify Mata. I think the judges are going to crucify her, and rightly so. And it has nothing to do with me being, this mean, angry guy. It has to do with the fact that the court system does not work if people don't trust it. Okay? And if I ever saw a future ruling from Judge Mata in any other case, I ever have any faith in it? Of course not. We need judges who are fair. We need judges who take the rules seriously, who care about the litigant in front of them, treat them with respect, which did not happen in this case by any stretch of the imagination. They're going to crucify her in my cheerleader case I've talked about. You don't want to make this longer than it already is, but I had a very bad judge who didn't like me. And that case went on for 5 years. We wound up winning in a heartbeat in the Court of Appeals. It was just like this. The judge ruled against me over and over and over and over again, slammed me. The judge hated me. We then went to the Court of Appeals, and the three-judge panel, who our federal judge on the case worked for, the Court of Appeals on a Proton basis or whatever, these were his colleagues, and they ripped him a new one in the appeal because he made the judiciary look bad, and that is not acceptable. I don't care what you think about me. I don't care what you think about Laura. I don't care how much you like Mata or Clayton. The court system is supposed to be better than this, and it wasn't. Not in this case. And for people like Dave Neal to sit around and just, oh, wow, and just ejaculate all over himself with joy over what happened here tells you what kind of person he is. And I'm going to have some words about him later, but it's enough. Aurora is hungry. I'm thirsty. Thank you for joining the Grab Him by the Pussy podcast. Aurora, what do you got last words? No, she just wants her dinner. All right, guys. Sorry if I got a little heated. It's, I'm a human being. I'm allowed to. I will talk to you soon. I don't know when. I'm not going to do this every day. I'm going to do it when there's something new to report. That's not true. And there is, unfortunately, we got to talk about what happened yesterday. I'll talk about that later. I'll see y'all later. Thanks for listening. Love. Bye. Holy shit balls. I don't know why I wasn't thinking that was going to be 42 minutes. I thought there must be a lot of pauses or something. No, he loves talking. Okay.
Oh my God.
Wow. Even that, even just the repetitiveness, I'm kind of glad well, I don't know. Maybe if we would have had the video, we could have listened to it in 2 times speeds, which I don't do. But oh wow, some of his predictions turned out very, very wrong, didn't they?
Ah, that was
Yikes.
so painful.
Yes.
It's as painful as reading his motions, which often sound like his blogs, which oddly sound a lot like the ramblings of his vlogs or his YouTube videos.
Yeah, that was something of a second video there. Oh my goodness. Oh my goodness. Good thing he's not a fortune teller. All right. Well, you're up next on the next one, Buff. You want to
I
pull that
can't
up?
top that.
Yes, you can. I've seen your reenactments. You do amazing.
Yeah, but it's Gingras.
Sanctions. Sanctions for all of us. All right. So I'll have you pump that one up. I'll get rid of mine now because I'm going to go to the bathroom and do a few things real quick. Let's see. So the next one takes place on November 15th. Remember, he said he's not going to do it every day unless it's about something of importance. That's not what happens at all. He does exactly what we know he's going to do, which is basically vlog every other day or every day, sometimes more than once a day. And this next one is entitled Grab My Kitty Legal Podcast
Nice.
because, YouTube probably didn't like the word pussy in the title. Season 1, Episode 3, Clayton Echard and Laura Owens updates.
Wait, how do I share it?
You click the little screen with a plus sign below.
Yeah.
And
Yeah.
click share screen and select
Okay.
that tab.
I forgot. I don't do this often.
You don't, so that's fun.
Did I do it right? Oh,
Yep.
God.
And then just zoom in on it so you and probably everybody else can read it. I usually make the window smaller so that way it takes up more of our screen too. There you go. Oh no, you just had the other one was better. And then just zoom in.
I don't know what I'm doing. All right. Zoom, zoom, zoom.
Well, the zoom's up at the top in that little bar. There you go.
Is that good? I can't see. I don't have two screens, so I have to switch back.
Oh, you
and
have it
forth
up in
between-
front of your. Okay, gotcha. Yeah, no, then I will tell you. Go ahead and zoom it in a little bit more, please.
Okay. Yeah. So it's like I'm saying, like I don't have two screens, so I have to zoom in.
All right, there you go.
on a
That's going to be
different
much
screen.
better.
It's still not going to work because it's not going to work for me.
Okay, well then whatever works for you.
Well, I mean, it's not going to work because it's going to look weird for y'all, I think.
No, it doesn't. It looks just fine.
Okay. Okay.
Somehow you got behind. I don't know. We got Mary.
See, he does it like he's leaving voicemails.
Yeah. Right, I'll be back.
Like my dad does when he leaves me a voicemail. Hey, Tara, it's blah 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 blah. 3:00 in the afternoon. Okay, whatever, sir. Okay. Okay, folks, it's Friday, the 15th of November. I've got some good news for you. I got some bad news for you. Today is a short one. 45 minutes is apparently not the sweet spot for a first-time YouTuber with controversial issues to share.
45 minutes. Grow up, David.
That's
not
how
long.
it was.
I know, but it's not very long.
I don't have 45 minutes today. You said that yesterday. Anyway, it's Friday afternoon. I am in a bit of a blue mood today, so we switched up it's reversed. I switched that light. I've switched that sign, and we're going with Dr. Phil. And this is ice water, by the way, in case anyone's curious. And I mentioned sitting and playing my guitar for you. I've got news for you guys. I can't play the guitar. My wife got me this Christmas. Well, you got me this for Christmas. I'm learning, and I have a book. I have a pick, and it's kind of a cool little thing because it's an electric guitar, but it's got a built-in amp, so I kind of do like one or two chords, but the whole point is that you can kind of mix it up. I literally can't play. Oh, but I'm going to learn. regarding yesterday, guys, don't. I don't. First of all, if you're a new subscriber to the not cat related YouTube channel, which is this, anyway, I got a lot of work to do. I got a name to pick. I don't know why people be offended by Grab My Cat podcast. That's the president of the elect of the United States said that phrase, and no one seemed to mind that much. Anyway, my name is David. It occurs to me that I should probably at some point assume that someone's watching this who is not familiar with me.
I'm pretty sure a lot of people were real upset about it, David. Do we live in the same reality? I'm pretty sure people were pretty upset about it.
He's very weird. Anyway, he just likes it any chance he can to bring it up. That's all. It seems like that's a personality trait of his. Okay. I should anyway, my name is David, and it occurs to me that I should probably at some point assume that someone's watching this who is not familiar with me, or why you are seeing me. Who is this guy sat here? My name is David. I'm a lawyer in Phoenix, Arizona. I am on YouTube for all of 3 days. I am primarily here because I'm involved in a really weird case involving my client is a girl named Laura. She was in a relationship with a guy who was on The Bachelor named Clayton Echard, and there was this big paternity scandal. And there's a lot of interest. There's a bazillion people talking about Clayton's side of the story, and as far as Laura's side, this guy. So anyway, yeah, yesterday didn't go very well as far as my video was too long. I don't know why people thought I don't feel like I was unfairly disparaging to the judge. I was very clear about explaining that. The facts are what they are, and I didn't claim to have any insight or knowledge beyond what I think most people already have, or already know. And yeah, so that process is going to work itself out. We already talked about that. We're not going to go over that again today. He just like is I don't even think we need, because we don't need another 45-minute video. I'm not getting paid by the minute on this, and honestly, it's just Friday afternoon. I just wanted you all to know, first of all, regarding the fair use issue that came up, you think you know what you're talking about, and you don't. I've litigated fair use issues before. There's no point in me making a video about fair use. There's too many better ones already out there, but you can't take someone's stuff. And this video is my stuff. And you just can't take it and put it on your channel because you don't want people to see it on my channel. And I don't care if you attribute it to me, and that's not the point. And I also don't care if you want to do a response video, sitting and watching my video, playing the entire thing on a monetized channel. If you think that's going to qualify as fair use, you're dumber than I thought you were. And that's really you. And that's really, I'm sorry, you can't do that. You think you can do that. You're wrong. I can go take you to court, and we can have a judge decide who is right or wrong. Do I really want to do that? I don't really want to do that. I want everyone to just get along and play nice.
Okay.
Oh, by the way, this is the new camera. My old camera, we might as well talk about it because it's out of service now. But there it is. It was a Logitech. I actually think this thing is done pretty well. I've used this for about a bazillion and a half Zoom meetings, and no one's ever complained. This is the new Sony, I think. I said it wrong. Z. I'm just too old. VF1. I don't know if I love it yet.
He's such a grandpa. What? He's not even that old. He's like in his 40s.
I
isn't he?
don't even
Or
know
50s,
if I
guess,
love
probably.
it yet.
No, I think he's in his 50s. Still, that's really young. Come on,
He's
get with it.
His ideas are actually quite like mine, which is so funny because I am all over the place and a little scatterbrained. And if left unattended or left unherded, I will go in a billion different directions. So it's kind of funny. I pick on him, but maybe it's because I see a little bit of myself there.
Maybe.
Okay. So this is a stream. I'm streaming directly to the PC. It only does 720p. When I'm direct streaming, that's a little lame. So I guess I have to record to the card. I don't know. I'm just scratching the surface of this content creation thing, and I don't know. I may be done with this next week. This may not be my cup of tea, clearly, but until I decide to leave, I'm gonna at least put a few comments out there when I can. I do want to talk about fair use. Wait, do or don't? I'm so close. I'm so confused.
I am
There's
real quick. I am very sad that we missed this part. Like, I do have FOMO about not being around when David released videos. I'm really sad about that. It's probably my biggest thing. But I'm like, man.
Yeah, I would have loved to have we
would have had so much fun.
I would have had so much fun pausing it and making yeah, it would have been fun. Okay. So don't want to talk about fair use. There's just no point in having that debate right now. All I'm saying about that is if you want to watch my videos and respond on your own independently to say, well, Ginger said this, and Ginger said that, and here's why he's so wrong to do that all day long in small portions of it. Take a clip here and there, fine. You don't even need my permission. I'll give it to you. You have my permission. Do not take my entire video and put it on your monetized channel. If you do that, you're gonna piss me off. Oh, we don't want to do that. Let's not piss him off.
We all know what happens when you strike a channel. Are you going to take everybody to federal court? Gingy, come on.
Yeah.
Come on.
I don't think so, sir. You're going to piss me off, and it's Friday, and I'm not gonna wait. And we're not gonna hurl out threats. Let me give one other little. We're not gonna hurl out threats. It's Friday. It's
Pukong Friday. It's fun. No threatening behaviors on Pukong Friday. It's a sacred day.
We don't give out threats on Friday. Let me give one other little bit of news. Wait, was the other news what was the other news? You got a camera? And people are responding to your videos is this your first day on YouTube? Reaction videos are a thing. Okay. Let me give one other little bit of news. I got an email today from a guy. I'm going to be polite. I'm not going on to reveal any names. I got the guy who emailed me as a lawyer in California who used to represent a certain YouTuber from Tennessee. Should we say that we'll just leave it there?
Is that Dave? And talk about Dave Neal?
I don't know, but I'm sure the chat knows.
Okay.
Say, and this lawyer, who's a nice guy, talked to him before. He asked for a copy of the appeal brief for that. I just filed for Laura, and my response to him was kind of the same as everyone else, I've got a lot of requests for that brief. I really think the best thing to do right now is let's hold off. Let's, yeah. Do I believe in the First Amendment? Of course I do. I know people are interested in this, sure, but I feel I have this weird feeling that it doesn't feel right to put out a 75-page 73, I think, but the 75 pages of argument that I put into the Court of Appeals. I don't want people to read that without hearing the other side's response. It just feels to me, it feels something about it doesn't feel right. The better approach, I think, is let's hold off. Let's get all the briefs filed, done, and then let's just let them all out there at once. And you can read mine, you can read Clayton's, you can read my reply. I actually emailed Wood Nick's partner or whatever is the guy who's going to be handling the appeal. Marcus is his name. I emailed him today and I offered to basically have a gentleman's agreement in that regard.
Did they go out to lunch?
Yeah.
Did they go to Topgolf?
He hasn't responded yet. And, and that's fine. He doesn't have to respond at all. We could theoretically, you could ask the court for a protective order, not allowing the public viewing of the briefs. They wouldn't approve that it's just Laura tried that earlier in the case in the trial court, and Mata denied that 3 times. I think anyway, I do think, and I know there's YouTubers out there who want to get the brief. It'll give you a good 2 hours of content, sir.
It was multiple hours, sir. We were here a long time yesterday. Also, here's how you know David is not confident in his argument at all, because it's such a slam dunk. Everything's going to be granted. He would want everybody to read that, but he doesn't. So I think that's very interesting.
Okay, it'll give you good 2 hours of content. You'll make a couple $100 off of it. Really? Are you sure about that?
I think we made like 12 cents.
I was gonna say, are you sure about that? But it wasn't in the height of everything going on, because we're too late as usual.
By the way, I had to wash some dishes so I could get a wine glass. So it's almost noon.
Did you just shrug off my comment? You just shrugged me off.
I'm sorry.
I will not be ignored.
I will not be ignored. What did you say? I'm sorry. I was trying to open this bottle.
It's not important. It's okay. You can hurt my feelings. I'll cry about it for at least 2 hours.
My Snoop Dogg 19 Crimes Cali Gold sparkling wine.
That would have been
champagne.
Perfect to drink during the KFD trial.
Oh, that's hilarious. Well, after reading the first one, I realized, you know what? I think I need to not be sober to keep reading these. So I need to be I need to, what do they call it? Method acting. I need for when it's my turn again.
Would this makes more sense if we're drunk? Is that how this works?
I think it might. I'm going to find out. It's for science.
It's like when you hang out with a bunch of people who've been drinking and you're like watching them all laugh and you're like, none of this is funny.
Yep.
And then you drink and suddenly everything becomes funnier. Uh-huh. Okay.
We'll see. I'm about to do it for science, of course.
Oh, Lord.
Oh, anyway, sorry, go ahead.
Okay, so you're going to make a couple of $100 off of him. He's probably going to bill you for that. Anyway, no, I'm just kidding. Sitting and reading, it just can we not do that right now? Like, wouldn't it just be better to just hear both sides of the story? Oh, I heard that pop. A little ASMR.
Send it through the.
I know. I guess I need to pick up drinking as a second hobby.
You're probably going to need to, yeah.
Starting to feel a little left out. I need a little touch of alcoholism like everybody else.
Just a little, just a tad bit. I'm just kidding.
Let's see. Remain willing to talk to any JFC YouTuber who's a reasonable person. The Law Vices guy, I don't know who you are, Law Vices, but you're friendly enough, and I'm willing to talk to you if you want to.
Oh, Jeff was friendly enough.
I know. Omar, I texted him. I think he was streaming today. And I said, I'm offering to talk to him as well. It's not really fair because Omar can't really argue Clayton's side of the case, nor could Law Vice's, I guess. Greg Whitnick, you want to do this together? Let's go. I don't understand. It's not cohesive. I don't know as much interest as there is. My number one thing is correcting misinformation. Really? Well, then maybe you can come on my new podcast. Misinformation. No, I'm just kidding. I just cannot stand people who I will not name giving false information about the law, about the case, about what my position is, what Clayton's position is. I just think it's devious of you to mislead the public. Why?
Right.
Why are you doing that? What do you think you're going to get with that? Public opinion on this is important, but it's not that important. I only care about 3 judges in Tucson who I haven't met, and I don't even know who they are yet.
Well, why are you doing vlogs about it then?
To say he doesn't care.
To say
you have to make
as one does
45-minute YouTube stream to let everybody know that you don't actually care.
I forgot how YouTube works. You're right. 6 hours, 45 minutes, whatever you need to tell people that you don't care, I guess.
Oh, Lord. Let's see. And tell people they're supposed to have focused on at the moment. And this isn't, I haven't really said it that many times. I'll say it. To me, this isn't about Clayton. I don't care about him. I don't have a beef with you, Clayton. It's not about that for me. It's about the law. And I do, obviously, I'm Laura's advocate. I'm trying to protect her. I intend to protect her. She deserves someone in her corner. That was a misstatement.
That would be a job. She can't do that. She can't even work the corner. She's never had.
Get so mad if you're on her corner. Like, this is my corner.
Call the police. Excuse me, police. Come arrest them because this person's standing on my money corner. It's scary.
They're working my corner. And it's not about money. She did want me to say, and we brought it up the other day at the podcast filming, which kind of went sideways. She has paid me in full for the trial work. I billed for the trial work. I billed her. I gave her some discounts and she paid me. And regarding the appeal, I'm not being paid. Not yet. That doesn't mean I'm working for free. I am billing my time. And at the conclusion of the appeal, I'm going to ask the Court of Appeals to make Clayton pay for those fees. They don't have to make him pay. It's discretionary. It's not mandatory. So my expectation is, if it goes that way, and if Clayton or whatever or whoever winds up paying my time that's been spent on this, that's fine. If they don't, that's fine. It's not about the money for me. It's about the law and the rules. It's about getting things right, which is a shame because I know the number one thing for most people was Laura pregnant? Was Laura pregnant? Okay, that statement was weird. Did she lie about this? And that's the only thing that you think will ever make this right is getting that cleared up. And the effed up thing about this is if we win the appeal, you're never going to know. You're not going to get the answer to that question, at least not from this part of the case. It could be answered later. Clayton could sue Laura. Laura could sue Clayton. We could have
Why isn't his answer, yes, my client was pregnant? Why are you as your lawyer still being like, I don't know. I don't know. But okay. All right. Sorry, go ahead.
I don't know if you're ever going to find out. Why not? Go get the records.
Right? It's almost like she's treating it like she was never pregnant. Interesting. Mm-hmm.
Let's see.
How
Okay.
much do you think his bill was that they paid?
I don't know.
Probably like $100,000. $2.
You get what you pay for. It couldn't have been that much. Let's see. Clayton could have some future, defamation trial or something down the road. Is that where I want this to go? No, I would like everyone to shake hands and go home. I wanted that pretty much from the first minute I got involved in the case. That just was not on the plate for Clayton's side. They didn't want to settle. And now we're in a position where Laura can't settle. She can't. There's nothing she can do. We have to keep going and fight until we win. So we're going to do that, but it is a Friday afternoon. And I think it's better to be low key. So the new camera, do we feel like it's in better? We're just going to go from that to the camera. So the new camera, you like it? Do I look good? Oh my God. I don't feel like it's that much better. I don't know. I feel like I'm looking a little more chubby than
Oh man, I really do miss that we missed this time.
It's the camera makes. Does this camera make me look fat?
Oh gosh, she's so funny.
Oh,
ridiculous.
Stop it. That was funny. I can't help it. I'm dying. Okay. Does this camera make me look fat? No, the fact that you're fat makes you look fat. Anyway, I'm looking a little more chubby than usual. That's not hard to do. The colors look okay. The sound I got to work on, I'm still using this microphone that's built in on this. Really? It's one of the cheapest things you can buy, sir.
Right? You got paid from the Owens, apparently. You should have a lot of money to buy a whole setup, but okay.
Let's see. I'm still using this microphone that's built in on this thing. It's okay. I got to get a better mic. I actually got a little lavalier thing, but I tried. It's not, we're not using that. So I'm going to get my setup dialed in. And in the meantime, don't worry about me. I'm not emotional. He's not an emotional man.
No, they never are, right? Never.
I'm not angry. If you think
That's why he fights with the internet. That's why he fights with the internet. But he's got it all under control.
I'm not wait a minute. I'm not angry. If you think I am, I don't feel like I've rewatched my video from last night, and I think I'm calm and lucid and fine. I don't feel like I'm freaking out and waving a gun. Give me a break. Okay. I'm not threatening anybody. I was trying to talk about how I felt at trial. And by the way, the one thing I will be direct about, Megan. Oh. You have no idea. First of all,
Megan Fox, I'm assuming.
I would assume that would be who he talks to. I get that you're a different kind of person than me. I don't know you, so I really don't feel fairly like I can judge you. But to say that you're going to prove that I wasn't afraid at a trial, because after it was over, we were kind of chilling in the parking lot. Girl, you did. You see the thing where Donald Trump got shot in the ear. Why is it always back to Donald Trump? Ugh, don't make me
But
say
also,
his
he just
name
said
so
something very
much.
interesting, right? So in the last video that we covered, he talked about how he had to bring his gun and leave it in the car. They needed security. He was so scared somebody's going to blow their heads off. And now he just said, well, after the thing, we chilled in the parking lot. You know what you don't do if you're scared for your life? Just sit and chill in a parking lot after a kid. Like, what? Okay. Okay.
You see the thing where Donald Trump got shot in the ear, and then what happens? Like seconds later, he's on stage doing this, like, right. And if I showed you a video of Trump an hour later, looking relaxed and calm, do you think that means that he wasn't afraid that day, or wasn't having, an emotional reaction to what happened? The fact that we got through the trial, we got from my car into the courthouse through the trial, and then back out in the parking lot with about 100 cops standing around. And the fact that those 100 cops gave us some peace and made us feel relaxed at that point, that doesn't mean we weren't scared in the morning. And I honestly could curse you out a lot but I get it. I don't know you, Megan. I think what you are is just an instigator. You're just one of these people who just runs up to people and tries to piss them off
Oh, wow.
because it's entertaining for you. And that's really sad way to go through your life. I think you should try to be, if anybody clips that and sends it to her, I did not say that. That is not me. It is not my opinion.
No, I think she would know that. But that's so, because he is such an instigator. Like his entire
He is. No,
personality
he
is being
does.
confrontational.
100%.
So that's interesting.
This next part, it's really sad way to go through life. I think you should try to be a better person than that. But I don't know you. Maybe you are a nice person. At the end of the day, I'm a nice person. But don't you dare question the sincerity of how I felt. You should sit down with my wife for a minute and see what she would tell you about how I felt that day. She still has some concerns. I don't go through life with fear. You don't scare me. If somebody wants to shoot me, you could shoot me. That's fine. I
Okay.
guess I could make a meme out of it and sell a watch. But if I live, but yeah, we should just all tone that crap down. To think that we're even feeling that way, does that make anyone on Clayton's side feel good? Is that what this is about, terrorizing people? I know that there's a few people who are absolutely getting off on that, and those are the ones that I am most interested in having a little conversation with later, shall we say. Other people who are just, don't like Laura, keep on with that. I don't care. And if you want to make YouTube videos about how much you don't like me or don't like Laura, I don't care. But don't disrespect me or Laura. As far as you know how we felt that day, you weren't in our shoes and you don't know. And I do. And I know you wait, and I I'm I got very thick skin, but I do have limits. Let's just say be respectful, both sides, be respectful to each other. I will make that commitment that Greg Woodnick and I have burned our bridges. The new guy, Marcus, and I have not. I do know him. I don't know him at all. I'm very happy to talk to him, have a friendly talk anytime he wants to. I am going to try my best to go forward as professionally as I can and not piss people off. Okay. I don't want to threaten people. If you steal my content and try and make money off of it so that I can't, I will sue you for that. Why wouldn't I?
Oh.
And by the way, the fact that you live in Florida and maybe you don't have a lot of money. Ouch. And the fact that you live in Florida and maybe don't have a lot of money, I can take your YouTube revenue stream if I have to. If I need to go to court and get a judgment, I just send the judgment to YouTube and they'll send your money to me. You know,
I think I know who
let's
you're
not
talking
do
about.
that. Let's just be more respectful to each other, both sides. And if anybody wants to call me out on me being too David, too Gingy, fine. Email me, text me. You got my number. It's out there. Just email me. In the meantime, I'm going to keep on trying to be, I don't know, not the worst lawyer you've ever met. Right now, probably scraping the bottom of the barrel, but it's Friday afternoon. I'm feeling good. Not feeling bad. I don't even care that much about the fact that I have a Trump sign behind that. What? It's all reversed, so it's all turned around. It's been a week. I hope everyone has it's okay. He's talking about his camera being mirrored. I was like, what the fuck do you keep talking about? I plan to do some in the meantime. I'm not going to share briefs until I hear back from Woodnick's side if they want to keep an informal agreement, not release them. Somebody can go down to the court and get a paper copy. Please don't do that. Let's just hold off. And for now, and then if
Why doesn't he want everybody to read his genius?
Because it's not genius, it's insanity. And then if Clayton's side comes back and says, you know what, go ahead and put your brief out now and we're fine with it. Okay, then next week I'll do it and I will sit because he wants to be the first one. Like he wants to do it. That's what it is. He wants to do an audible read along with his brief that everybody can download and
shit and get off the pot. You have it, sir.
I don't want anybody else to do it. And put your brief out now. We're fine with that. Okay, the next week I'll do it. I'll sit and read it before I release it because I want people to hear my side of it before I get the side. Anyway, have a great weekend. 16 minutes, not bad for me. I will see you. I'll be around. Text, email, you know where to find. He keeps telling these people to text and email him.
Which is crazy. And then getting mad that people
harass him.
Yeah. So,
yeah, it's hilarious. Have a nice time. See you later. Bye. Oh my God. It's the I'm tripping on. Yeah.
Yeah. He does it a lot. All right. So the next one we have for you is from November 17th. Right? It's 1, 2, 3. So this is actually apparently Laura Owens and David on his YouTube channel where they're discussing the Clayton Echard appeal in the Arizona paternity case. I don't know how we're going to differentiate who's suing who, but we're just going to, I have a feeling she doesn't say very much. And then it's just a whole lot of him. So
how could she? He talks so much.
That's what I think.
I mean, they both equally talk so much. They probably
so much. Right? People said, you two love the sounds of your own voices. Well, let me introduce you to these two people, okay? Because they really, really love it. They love the smell of their own farts. Okay. All right. So this one apparently is going to be a long one. I don't know. So, hold on. I got my drink here so that way I can be in character. My method acting. It's very bubbly. Okay, well, folks, it is Sunday, the 17th of November, 2024, and Aurora just left after sitting here for 10 minutes. Oh, no, she'll be back. She'll be back. She can't leave anyway. Hi, everyone. My name is David Gingras. I am not a stand-up comedian. I am barely a lawyer. You said it. You said it, not us. You said it, sir. hanging in there in Phoenix, Arizona. Joining me today on the not a podcast, don't have a name for it, is the pregnancy faker extraordinaire with a cool back whatever filter thing you have on there, Laura Owens. Let's not introduce it as pregnancy faker extraordinaire. Whew, okay. Let's hear it for Laura. Crickets, cricket noises. So I said before that I wasn't going to release my appeal brief, and nothing about that has changed, other than the fact that last week I emailed Greg Woodnick's partner Marcus, and I told him and asked him whether I kind of wanted to get his feeling on brief sharing. Did he have a strong feeling about it? Did he not want me to release my thing? I don't know. I haven't really talked to the guy. What? You just said you email. Okay. I've never spoken to him, just emailed. And Marcus responded on Friday afternoon, I think, and said basically he didn't care about releasing briefs. And also he added a comment saying, look, anybody can get it from the Court of Appeals. JFC has probably already done that or is about to. And that that comment from him, those two things, that he didn't have a strong feeling about not sharing them, and also that JFC is going to have it in a day or so. Anyway, that has pushed me to the point where I think it's just time for me to read this for you guys. Um, I'm not going to read the whole thing, as you can see, if you can see the screen. Oh, dear God, please don't let us do it all again.
Is he reading this? Like,
Uh,
is he actually?
I think so. I think.
Oh, for fuck's sake! Can we?
Oh, Jill says she hardly says a word as one. I think he's already been noticed of bar complaints. I think he said that in the first video, that he's gotten a bar complaint from Mata, and he filed the judicial complaint against her. Greg won't have lunch with me. Nobody will have lunch. Go and play golf or get nachos. Where was I? All right. Hopefully, it's showing 73 pages. That includes the table of contents, table of authorities, and a couple pages at the end. So the brief itself is about 65 pages of argument. Now, I'm not going to read all that. That the factual part, which is the first 15 pages, to me, that's worth hearing. I think that encapsulates what the case is about, what the appeal is about. And as I've mentioned before in other videos, the point of an appeal is not to have a second trial. We're not allowed to have a second trial. We love to have a second trial, but this isn't the place for it. We are in the Court of Appeals, and they are a court of review, and they can only review calls that have been made on the field in the game. We cannot make new arguments for the first time on appeal. We can't introduce new evidence for the first time on appeal. So when you hear, I swear to God, if we're doing the cup thing again, David, I'm going to be very upset with you. So when you hear our brief and when you see our arguments, this is necessarily a rehash. It is not, if we had a second game to play in the World Series, and game one went to Woodnick, and now we're in game two. You know, we are we going to change our strategy? We can't. That's not what this is. All this is a review of the game that we've already played. And the cat is back and she will interrupt. And I'm glad that she's here to interrupt. And by the way, I also have behind me now two fake auroras. One is an oven mitt. The one on the Biden side sign here is an oven mitt. The other one is looks like a penguin on the other one. What a penguin. Yeah, kind of this one. Yeah, that's a big stuffed thing. They're both there. That one actually looks creepy, but it's a real oven mitt that looks like Aurora. And anyway, and and I also have a new microphone. I'm not using it for this because it's just too confusing with what we're doing. So let's not take too much more time. Let's get through this. I'm only going to do the first 15 pages, and that to me is a fair compromise. I said before, I don't think it was fair to let JFC have our full brief because this is our side, and I think it's better and more fair and it makes more sense to have our side, Clayton's side, and our reply all in one go. Then you can read it. That to me is the way that people should think about this in their heads. It shouldn't be you just hear our story and then boom, it's you have 40 days to think about it because Clayton's brief isn't due for 40 days. And to me, that didn't feel fair. That is more about the legal arguments. The factual stuff is not argument, and it's not. I don't think it's very controversial. So I want to read this that people don't think we're hiding something, nor do you think that we're hiding something. Yeah, she's like, you're holding my lunch. Anyway, I'm assuming he's talking about Aurora. So anyway, so we'll get to that. We'll get to that. So okay. So Laura, is this moving okay for you? You can see it on your side. Yeah. Okay. Okay. So the brief, this type of brief is controlled by the appellate rules. They tell you exactly what they want in it. You have to have a table of contents. If you want to, you can screenshot this. I'm probably post actually the pages that I'm going to read and show. Don't worry about screenshotting them. I'll share them so that people can have them. Again, we're not trying to hide anything here. We're just trying to get Laura's side of the story out there and her arguments about why she should win. So here's I'm just going to read this and you maybe Laura if as I go along, if you have questions or if you want to add something, please feel free. Your hand actually just ask you one thing that I'm sure JFC people are going to want to know, and that is can they share this on their channels? What a good question. And actually, you now reminded me of something else. We've talked about, he's never going to read this brief. Uh, you now reminded me of something else. We've talked about this about 1,000 times. The Arizona rules of professional conduct that are binding on lawyers say that I'm not allowed to talk about your case unless I have your informed consent. That is 1.6. Do I have your informed consent, Laura, to talk about your case? Uh, you most definitely do. Thank God. I wasn't sure. I was not sure. It's just, people say I'm walking into an ethical landmine here. So, okay, he very much is. He very much is. So, oh my goodness. And wait, then I interrupted you. You had a question for me. What was the question you said? Can they share it? You can. You may not share this video in its entirety. That is not fair use to play our entire video. No, no, no. You think you know copyright law, folks. I have the freaking Copyright Act in my drawer from law school still. Do you see how this thing is well worn? I've read this cover to cover. I've litigated copyright law cases. I have studied copyright law in law school. I have won copyright cases. I may have, I don't know if I lost any, but I've settled a few. If you are not a copyright lawyer, you know it's fine. You can go do your Google research or whatever. You don't know the law. I do. And I'm not. It's not about you, chest thumping. It's about, I don't want you to steal my content and make money from it. And it's just not fair use is a thing, absolutely a thing. I've litigated fair use. I know fair use like the back of my hand. Fair use is using a small amount of someone's work for purposes of commentary or criticism is one part of the factors of fair use. It is not automatic. Oh, I'm commenting on this video, therefore it's fair use. Wrong, wrong. If you're going to give out advice like that, you should stop people in the grocery store and give them medical advice because it's as irresponsible a thing to do. If you want to use 5 minutes of this, how long have we been recording? I don't know. I can't see the timer on my thing. 5, 10 minutes. This is going to be about showing up online. I would guess it's going to be about 30 to 40 minutes. If you want to use 5 minutes, 6 minutes, no problem. Don't I give you? I give you my permission to use a minute expert excerpt for the purpose of showing Laura and I sitting here. And if you want to talk about us and use a little clip, that is fine. I will not raise an eyebrow for 1 second. You have my permission. And if you want to use the whole thing, not fair use, and I will not tolerate that. So I think it's fair. If you think you're right, roll the dice, baby. Um, now, let's just get into it. Did I answer your question, Laura? Yes. Oh, I'm sorry. Yeah. Yes, you did. Yeah. Okay. Awesome. Okay. And guys, I know people want to talk about this. I know you're interested in it. I'm interested in it only insofar as I'm trying to get Laura some peace in her life. And I'm trying to get us to a place where we're not in, not this needs to end. I want it to end. Laura wants it to end. And we felt that way for how long? I mean, you tried to dismiss this almost a year ago, yeah? So Clayton is the one that has not allowed that to happen. And you can argue or we can speculate about why he's taking the position. Whatever, for today's purpose, this is how we're going to get you to the next stage of hopefully this is over, okay? Introduction, this case presents oh, this is where he's reading now. All right. He's now reading his appeal that we read yesterday, and it was awful. Okay. Introduction, this case. This case presents some bizarre, interesting, frightening, and salacious facts. The story involves sex, celebrity, even an alleged fake pregnancy that includes an inexperienced trial judge who apparently broke the law to ensure a victory for a famous litigant from a popular TV show. Um, I'll interrupt myself.
Thank you.
He is not getting through these 15 pages without that.
Somebody
Wait,
should
hold on.
just stop him.
Let me
He
look
should
up
have
here.
StreamYard issues.
Chat. Because I don't have the chat open in front of my thing. Because then I get lost. Hold on, let me do this so I don't get lost. I'll interrupt myself. She says that's not informed consent. It's consent, but it isn't informed. Statements can be used against her in criminal investigation and civil lawsuits, etc. Oh yeah, it's not great. It's not great. I can't wait to see if it's going to be used that way. Bunch of dum-dums. I'll interrupt myself. Mana was only a judge for I think 2 years, roughly. I don't know her full background, but she is not a judge who's been around for a long time, and that's I don't mean that as a criticism, which is exactly why I said it the way I did because it was, but the fact that she is a judge, I respect that. The fact that she is new at it, I have a friend from law school who's a superior court judge, not in Arizona, but I know that it is a learning curve. It is you think the person's a judge, they automatically know everything about everything. They do not. And believe me, I actually in law school had a professor who was the brother the professor was a federal judge, and his brother was on the U.S. Supreme Court. Did you know that, Laura? Um, no, I did not. Um, and then he goes on to say, well, one of my federal criminal procedure law professor at the University of San Francisco, his brother was on the U.S. Supreme Court. He's retired now. Briber is his brother, was and is still is a federal judge in San Francisco. He was my professor, and I thought, judges knew absolutely everything. They absolutely don't. It is a learning curve, and that's why when I talk about law, well, this is going to be a long video. If I stop every sentence when I talk about the law, the judge, a judge's job is to make the correct decisions under the facts. And the lawyers are like, they say they're officers of the court. We are there to help the judge get to the right conclusion because it's hard, man. There's a lot of different angles to the law. There's a lot of different pieces, area of laws that judges may not have ever encountered. So the fact that Judge Mata was inexperienced, I threw that out there because it's true. And I think what you're about to hear in terms of my characterization of the timeline, it looks like an inexperienced judge who's not following things as they should. All right. So can we get back to reading this? All right. I'll try not to stop every sentence. All right. So Judge maybe broke the law to ensure a victory for a famous litigant at the end of the day. The strange facts of this case are almost irrelevant to this court's task, answering a very simple yes or no question. Do the rules of procedure matter? Or can the rules be casually tossed aside when they require an undesirable result? Or, I'm sorry, when they require an undesirable result. There's supposed to be a question mark there. I remember that from yesterday. This rhetorical question answers itself, of course. The rules adopted by the Arizona Supreme Court matter like all other statutes and regulations. The procedural rules carry the full force of law. All judges, all lawyers, and all litigants must follow. Then, whether they agree with the rules or not is undisputed. That does not happen here. The trial court ignored one of the clearest and arguably the most important rule in all of civil litigation, the safe harbor provision of family law, Rule 26. Oh, look at this. And I have a
I'm
drink.
out. Bye. I'm leaving. I'm done.
I got a drink and everything. Oh, wow.
I'm
Mama's about to
I'm
get
done.
shit-faced in 15 minutes.
I'm done. I'm running to the store. I'll be back in about 10 minutes with mine.
Buffy's going to start shrinking.
I
Today's the
am.
day.
I
when
haven't
Buffy-
drank in like 10 years, but you know what? Well, actually, it's not true. Well, no, actually, it's probably true.
Probably.
But I
I've
might
never known
today.
you to drink in the last, 3-something years. Hold on, my phone is buzzing. Make sure it's not important now that it's school time. Anytime my phone goes off, I'm uber paranoid that it's the school. All right, where was I?
It wouldn't take much to get me drunk. It's been 10 years. So
I was gonna say you have one glass of this champagne, you'd be like, I am wasted, and this makes so much more sense.
you would just have to mute me.
kidding.
It would get
All right.
weird fast.
I love getting weird. We are weird. Everybody get their drinks ready because you're all gonna need it. So, Safe Harbor, Family Law, Rule 26, which is the family court variant of Civil Procedure Rule 11. Rather than applying the safe harbor as the law requires, the trial court transformed it into the proverbial screen door on a submarine, a pointless, useless nullity. The obviousness of this legal error is surpassed only by the ease with which this court may correct it. by reversing the lower court's judgment and remanding this case with instructions to dismiss the action with prejudice, of course. With prejudice. Of course, this appeal raises other arguments and issues, but the court not reach. I see a hand going up. So that was me. Oh, I'm sorry. I see a hand going up. No, that was me adjusting my hair. Sorry. Okay, of course, this appeal raises other arguments and issues, but the court needs not reach or decide any of them. The trial court's error of law on the first point is fully dispositive of this entire appeal. The next section, statement of the case and facts, the rule of appeal procedure, actually say you can do that in two sections. Now, I've combined it into one. Most points in this appeal involve legal errors, which are subject to de novo review. Laura, do you know what de novo review means? You have explained it to me before, but how about you explain it for everybody? Yeah, de novo. There are many different levels of review.
He talks to her like she's a 5-year-old, like
Yeah.
like Miss Rachel. Do you know what de novo means? Say it with me. De novo.
Oh gosh. Oh, that's funny. That's exactly what it is. Oh wow. Okay, where was I? We're going to learn what de novo means. There are many different levels of review. It starts the lowest level of review. Excuse me, I'm not even sure what to call it. Abuse of discretion is probably the lowest level. There are levels where the Court of Appeals doesn't want to second guess a judge as far as when you have a trial, the judge is sitting there looking you in the eyes. They're looking at your body language. They're they're listening to your speech. They get to see you and kind of evaluate you the
So
way
they're
that people.
judging.
Yes, they're judging. What are the odds? The judges are judging, Buffy.
Kind of in the title, right? I don't know.
Do
Makes
you
sense.
know what judge means? Oh man. Oh, I haven't even had a full glass yet. Jeez. Body language that they're listening to your speech and okay. Kind of evaluate you the way that people evaluate other people in front of them. Do I trust this person? Do I like them? The Court of Appeals doesn't have that benefit. They have a dry record. They have paper reams of paper. Court of Appeals does not want to, and generally, as a matter of law, will not second guess a judge's factual findings. They will defer to the trial judge's decision on the facts. So if Laura says, I had sex with Clayton, and Clayton says, no, I never put it in the Court of Appeals. Mata said, I guess she said that she believed Clayton didn't. She believed Clayton, didn't believe Laura. The Court of Appeals will defer to that judgment. They will not look at the facts and they say, gee, if we were sitting in the courtroom, we might have ruled differently. They will not do that. That's called deferring to the trial court's factual findings, de novo review. Oh, finally, we're going to learn what it means. Oh, thank God. What would we do if David didn't tell us what it meant? Goodness.
I don't know, but I feel like the hand puppets actually probably would have worked for this particular stream.
Damn it. I've wanted hand puppets for so long. But yeah, it would have been great. Maybe we could refilm these as hand puppets.
Oh no, I'm not going through this again.
Does that work for fair use, David? Well, you dumb internet YouTube creator, let me tell you about fair use. See, I could entertain myself for hours. Okay. Anyway,
We do.
we do. A few other people. Where are we? It's all about having fun. If you're not having fun when you're making YouTube videos, what are you even doing? What are you even
Oh, he's making it hard. He is painful.
doing? That he is. Now, de novo review is something different. De novo review means from new, from scratch. And that is generally the rule. That de novo review means we do not defer to what the trial court did. We don't look and say, well, we don't necessarily think we would have done the same that Mata did, but we're just gonna we're gonna let her give her the benefit of the doubt. De novo review is completely the opposite of that. He's really making this very clear. Not at all. Not at all, but okay.
Clear as mud.
Clear as mud. Yes. De novo review is I'm looking at this and what do I think is correct, regardless of what Mata says. And that is de novo review. That's the highest level. That means that what Mata did before doesn't matter. Most of our legal arguments in this appeal are the standard of review. Are the standard of review is de novo. So we're going to talk about what Mata did. We're going to explain why it was wrong, but the Court of Appeals is not going to give her the benefit of the doubt. They're going to look at the rule, read the rule, look at the facts, and decide what was the law, the legally correct result, and if that matches what Mata did, then we lose. If the Court of Appeals doesn't agree with Mata, then it will reverse. Okay? Is that you? Am I explaining that okay? So most issues in the appeal involve legal errors that are de novo. Although Laura, certainly, I don't even know how the transcript. What does this even mean? I'm just analyzing now. I don't know. Just analyzing now. Although Laura disputes many of the trial court's factual findings, she recognizes this court will generally, quote, defer to the trial court's factual findings, but review de novo all legal conclusions. So that's what we're doing. The Court of Appeals knows this, by the way, but the rules say, and in every level of my argument, I have to tell them what standard of review I think applies. Okay, so therefore, plentiful and egregious factual mistakes, notwithstanding factual errors, are not the primary focus here, and they're not the primary focus because the review standard is so differential. It's just not unless Mata made a factual finding that had no evidence behind it, and we do have that with the Planned Parenthood thing. They're going to defer to her. They will not defer to her. Oh, on the Planned Parenthood thing because there's no evidence at all for that. Okay, those standards in mind, Laura offers the following background facts for context. And I said before, this is essentially where the three judges who are reading this have never heard of our case and do not know anything about the facts. It is my job to guide them like a tour guide. And like any good tour guide you have ever been on the Jungle Cruise at Disneyland, I'm going to point out the things along the way that I feel are important. It is not my job to point out every single thing about every single nuance and every fact and every, argument. That is not my job. as a tour guide. This is the Court of Appeals. Or I'm sorry. The Court of Appeals needs a summary of the facts to help them understand where are we going. And Clayton gets his chance to respond. He can tell them that he agrees with my facts and doesn't have anything to add to them. He can offer his own if he thinks that something about a different part of the story is important. He can add that. So when you hear what I'm about to say, don't judge that Gingras is excluding or leaving things out on purpose. I'm just trying to streamline, trying to make this understandable. Okay. All right. So we start at the beginning, May 2023. Laura's pregnancy claim, and by the way, in this brief, he's he's really good at interrupting himself. It's very much like us. So he's on his way to being a content creator. A good one, that's debatable. Are we good ones? That's very debatable. Not even he can focus on his appeal because it is mind-numbingly exhausting. All right, where was I? By the way, in this brief, all of these are working hyperlinks. The Court of Appeals in Tucson has an online record where all of the briefs and all of the transcripts and everything that happened are on their server, and they are hyperlinked in here. I'm not going to click it right now because I don't want to mess this up. Excuse me. But when you get the actual brief, that's why I didn't want you guys to get a paper copy. If you had a paper copy of this, the links wouldn't work. I'll post a copy that has working hyperlinks. You can click them, and they will take you. Every single thing that I talk about in here has to be supported by something in the record, and it is so in her establishment petition, which is I'm not going to read the citations in her establishment petition, and later in her trial, test Laura, and the rules of appellant procedure say they want you to use parties' names, not appellant and appeal. That's boring, and I agree. I will say that is one of the few things that I've agreed with David and how he doesn't use petitioner and respondent because it's boring and stupid. So thank you,
I do
Ivy.
appreciate that.
Oh, you're about to take off. You're downloading, watching us. Thank you, Hellville. Have a
Where are
safe
you
flight.
going?
Where are you going? Are you going back home? Where have you been? We've been out of the loop. I've been out of the loop with bad weather,
I'm out
loss
of the
of
loop too.
electricity, trying to catch up on my days lost, then a flooded basement. I don't want to talk about how this weekend's going to be. I'm over it. And it's supposed to storm tomorrow. They had this
Oh.
shutdown. So in Ohio, we're going to side quest here so I can
Side
get a brain
quest.
break from Gingras. But so, we got all this flooding overnight last night. And so like half the city flooded. And we have Interstate 70 that runs from one end to Ohio to actually it's a huge interstate that goes across multiple states. All right. 70 is a very high commercial routes, all of that. The flooding was so bad, they had to shut down that highway because it was undrivable, which never happens, like at all. They had canceled a bunch of schools. My son's school didn't cancel because it wasn't his district, but yeah, it was pretty wild. My basement, the water has all cleared out, though now we get the joy of throwing everything away, itemizing things for insurance. Not excited about that.
I'm
So,
not smiling because I'm happy. I'm smiling because this is like Tuesday in like Louisiana.
yeah, I know. You're like, girl,
random
what?
rainstorm in Louisiana. It's like, oh wow.
Yeah, we don't usually get massive flooding like from my point up in Ohio. It's usually the southern Ohio, because it's like the baselines of the Appalachian Mountains. I'm sorry, Appalachia Mountains before Lady and Gray yells at me, even though that's not what everybody's taught at school, Lady and Gray. But so it's kind of it doesn't happen very often up here. Though in Columbus there was the Great Flood of like the early 1900s where a bunch of people died. That's why we have flood levies now. And I used to work at Spaghetti Warehouse, which was in like this old, huge old warehouse building. Like we sat 700 people. That's how big this building and restaurant was. Anyway, many people believe it was haunted, and it was creepy and weird because it used to be an ice house. And during this flood, they stored all the dead bodies in the ice house because
Oh,
that's how ice used to be made and delivered to people. Anyway, so it does happen up here, but it's not at all very often. But all of the lakes and the rivers that we're used to, uh, sorry, I had to. I had to.
well, don't go chasing waterfalls.
We don't really have any waterfalls, so we just have the rivers and lakes that we're used to have now flooded, and are going
Well,
very quickly.
you should just stick to those.
Just stick to our rivers and lakes. That's all we got. No, actually, no, I do think there are some falls, but I'll be honest, I've seen them once, and I was not impressed. I was not impressed. I was like, that's a waterfall too? That's okay. I can't believe I hiked for this. I hate hiking.
I was just quoting waterfalls. Were we on the same page?
Yes,
Okay, and then
absolutely.
you went on it. I was making sure
Yeah.
because I was like, did she take me literally? Because now she's actually talking about waterfalls.
Nope.
Because
I too was doing a TRC reference.
Okay, so I just wanted to make sure. I was like, wait a minute. I didn't actually expect her to go in and explain any waterfalls because it was just.
I am in. I wonder if this sherbet Alani would taste good in a champagne. Let's find out.
Well, I said it would probably taste good in a vodka.
Well, I just poured. It'd be like a spritzer, an Alani spritzer. Let's find out. Oh, that's delicious. Oh no, it's so good.
Which one are you drinking?
The
Which
Alani
Alani?
sherbet swirl. So a little champagne in it. It's bubbly. It's quite a nice spritzer.
So, wait a minute. The sherbet swirl, like a orange sickle type thing? Like, what is a sherbet? I've never had one.
You've never had sherbet before?
No. What's a
Oh.
sherbet?
It's like ice cream, but not. There isn't like dairy in it,
Okay.
but it's fruity, right? So there's different flavors. There's like orange, green lime, raspberry. This is like a combination of all of those flavors into one. It's delightful. And somehow they've made it kind of creamy, which is weird because it's a drink. Dean loves sherbet. Me too. And the Alani tastes exactly like melted sherbet. And it's
So-
delicious. But it's non-dairy.
So it's a fake fruit frozen thing?
Close enough, I guess. I don't know how do you describe sherbet to somebody? Do you guys just not have it down there? Is this one of those weird
might.
north-south things?
We might. I don't know. I also have the palate of a 6-year-old.
Have you had frozen yogurt?
Yes.
Okay, it's kind of like that. Because it's not as like dense as ice cream, right? And heavy.
Mhm.
I'd say it's kind of along the yogurt side, but it's not frozen yogurt.
Because I like frozen.
Anyway,
yogurt. I prefer it over
delicious.
ice cream, but
And yeah, fun fact that we talk about once is that everybody calls it sherbet, but there is no second R in sherbet. It's sherbet. But I refuse to comply.
and he spelled it correctly. Oh.
I know. I refuse to comply. So it is what it is. All right. So now I got my sherbet spritzer.
No, I
which
didn't know that.
because there is a champagne drink where you put sherbet in and then pour the champagne over it. And that's exactly what it tastes like. And it's delicious. Yes, you can put it in 7-Up or Sprite. Mm-hmm. Yes.
Oh, okay.
You have to get some sherbet. I love it.
Okay, so probably not. Again,
Why?
I have the palate of a 7-year-old. And
I tried to spell a sherbet. But autocorrect was like, no, you idiot. There's no second R. The one time autocorrect corrects it rightfully instead of the other times where it was like, what? That's not even close to what I was trying to say. Why?
Kids love sherbet. Huh?
7-year-olds
Okay.
love sherbet. 40-year-olds love sherbet. Everybody loves sherbet.
I probably won't.
You are so stubborn.
I
fine.
am.
It's
And
fine.
also scared to try new things. I stick to the foods that I know. I order the same thing at every restaurant.
Baby Buffy might like it. You could try some of Baby Buffy's.
No, Baby
He might
Buffy
like
will
it.
not. He is worse than me.
He's worse than you. Yeah, I can see that.
He
All right,
probably gets it from me.
back to whatever dumb shit David's going to say over here. Where did I even leave off? Oh yeah. So we're beginning hyperlinks. Hold on, we already talked about those. Later, her trial test. Okay, here we go. You can click. Will take you. Every single thing that I talk about in here has to be supported by something in the record, and it is so in her establishment petition, which is. I'm not going to read the citations in her establishment petition and later in her trial. Laura and the rules of appellate procedure say they want you to use party names and not appellate or appeal. This is where we left off. That's boring, and I agree. Laura claimed that on May 20th, 2023, she had a brief one-night sexual encounter with respondent Clayton Echard, though the transcript has a funny way of spelling that to nerd. Sorry. The sherbet flavored champagne is getting to me already. My spritzer.
But now I want some.
Now you want see?
I don't want sherbet though. The texture I couldn't do.
There isn't any texture to
But it's
it.
fruity. It's a fruity.
Oh, that's you hate fruity things. That's true. You do hate fruity flavors. There is not like chunks of fruit in it though. By the way, just in case. There's not any. Usually, at least all the sherbet I had never had any like chunks of fruit in it. But yeah, I forgot you don't like fruity things. Fucking weirdo.
But I do like the Alani Cosmic, but I think it's because it tastes more like candy.
It does taste that definitely tastes way more like candy. This tastes exactly like melted sherbet, which is amazing.
Oh,
Albufy doesn't really like it either.
Flavors.
His favorite's the cosmic one, but
that's my favorite. Like I really like that even more than the cotton candy now.
But he is a nerd, so it's fine.
I like nerds.
Mm-hmm.
I don't know if I should say that again.
Nerds. Me too. We have a type. Okay. 11 days later, Laura learned she was pregnant by taking a home pregnancy test, or HPT. Laura sought medical confirmation of the pregnancy the next day at a Banner Urgent Care facility in Scottsdale. The pregnancy test at Banner Urgent Care was positive. On June 17th, 2023, Clayton invited Laura to his home in Scottsdale to discuss the situation. When Clayton arrived, my eyes are going when Laura arrived. Okay. When Laura arrived, Clayton, doubtful of Laura's pregnancy claim, surprised her with a home pregnancy test, which he insisted she take immediately in front of him. Laura took the test. Clayton provided it was positive, and I then quote from a finding that Mata made that Clayton provided a pregnancy test for Laura to take. Both parties agree the test was positive. Now, Clayton later confirmed seeing the positive test in an email entitled something to consider, which he sent to Laura a few days later on June 21st, 2023. In that email, Clayton made several admissions about the pregnancy, even after seeing a positive pregnancy test. I still had doubts in my head. Something was telling me to look deeper. So I did. I came up with a theory that could be realistic, considering you only performed oral sex on me and no vaginal penetration occurred. The chances of you being pregnant seemed considerably low, although again, maybe rubbing up against one another allowed us to make a sperm to make itself inside of you. I'm sorry that we are sitting here reading
I'm
this, Laura.
so grateful that you are reading this and not me, because this is usually
It is.
what I get to read.
Second day in a row, I've read it for you.
I
Don't tell me
know.
I never did anything for you.
Usually I'm the one reading all this sexual stuff.
Right?
When you've conveniently left the screen and I'm just like, okay.
Conveniently. What a baseless conspiracy
Accusation.
theory. Yes. Yes.
Baseless.
Start a cult about it, apparently. Go make a 6-hour live stream about it. I
I
don't know.
will. I've already planned it. I have a whole script.
Oh gosh. All right, where was I? Rubbing. There's rubbing. Okay, yeah. I'm sorry that we are sitting here reading this, Laura. But it's a very low probability, nevertheless. It is one. So here's Clayton in his email to you saying it is possible you were pregnant based on what happened. Laura and Clayton discussed the situation over the next several weeks, but could not agree what to do after another positive home pregnancy test on August 1st. Now, just to clarify, Clayton has only said there was dry humping and finger banging.
I would say I'm not
And
going to make
blowjob.
the gesture. I almost did.
You
I was
almost-
like, no.
It's fine. We
No.
already had the cups and the ball
The
cupping
cupping of the
earlier.
balls? Yeah, I already did that. I mean, you did that. I just mimicked you.
Fukong Friday. This is why it's our favorite day. I mean, it's fun. Why not? All right, where was I? Another positive pregnancy test on August 1st. Laura filed her establishment petition later that same day. And by the way, I did not mention the July 23rd tissue passing here because we're not relitigating the facts.
Yes, we are.
I can't include every little nuance and detail. It's not because I'm trying to trick them or leave stuff out. It's just I'm only talking about what's relevant to the arguments you're about to hear. Okay. I don't buy that because wasn't it listed in the judgment statement of facts in her thing? If that's what I don't know. Maybe it wasn't. Maybe that's why. Okay. Litigation begins after 2 months of unsuccessful private discussions and multiple private positive pregnancy tests. By that point, 5 of them you had, Laura. 5. Uh, um, on August 1st, 2023, Laura filed a petition to establish paternity. On August 21st, Clayton filed a response denying paternity from the inception of the case and for months to follow. But both parties were pro se, meaning they did not have lawyers in September
Are we
2023.
Is he really rereading all of this?
Yes. Yes. And unfortunately, we have to read it because we don't know where he's going to interject and say something stupid. So thanks, David.
Oh, okay.
I know. Laura and Clayton, at least we don't have to do all the Rule 26 arguments. So there's that, hopefully. Laura and Clayton agreed to submit samples for DNA testing through a company called Ravgen. A Ravgen representative later indicated the tests were inconclusive because there was, quote, little to no fetal DNA found. Thus, there was insufficient genetic material to establish or exclude Clayton as the father within the 95% certainty requirement of the Arizona state statute on paternity. Bad news arrived a few weeks later on October 16th, 2023. Laura had a blood test which showed her HCG pregnancy hormones were 102. Although this test confirmed Laura was still technically pregnant, the level of 102 was far lower than normal for a healthy pregnancy. At this stage, this indicated Laura had either miscarried or that a miscarriage was inevitable. On November 14th, 2023, Laura saw a medical provider at MomDoc and OBGYN facility At that time, Laura was given 2 pregnancy tests, both of which were negative, confirming her pregnancy had failed, and she was no longer pregnant as of the date after learning. Okay. By the way, remember, none of this is true. Well, those things are true. Her pregnancy in general wasn't true. Where was I? She was no longer pregnant. As of that date, after learning of the miscarriage in November, Laura, who, like Clayton, remained pro se, no lawyers, filed nothing further in the case. She pursued no discovery and otherwise had no case related contact with Clayton due to inactivity. On December 4th, 2023, court administration notified the parties the action was scheduled for dismissal. After receiving the dismissal of impending dismissal, Laura filed nothing further and took no action to keep the case active. However, before the case was dismissed, Clayton retained counsel Greg Woodnick, who appeared and immediately filed pleadings, seeking to avoid dismissal. Not something that a defendant would normally do. Not that he was defendant, he respondent. First, on December 12th, 2023, Mr. Woodnick filed a motion for leave to amend Clayton's response to the original petition. Next, on December 13th, Mr. Woodnick filed an expedited motion to extend the dismissal date and a request for an evidentiary hearing just days later on December 22nd, 2023. Laura retained counsel on her own. 6 days later, on December 18th, 2023, Laura moved to dismiss her petition with prejudice, explaining, quote, petitioner is not now pregnant with respondent's children. There is no paternity or maternity to establish as petitioner is no longer pregnant. Accordingly, this case must be dismissed on January 3rd, 2024, after Laura moved to dismiss her petition. All right, I'm sorry, no. After Laura moved to dismiss her petition, Mr. Woodnick filed another motion for sanctions. In his motion, Mr. Woodnick claimed Laura violated Family Law Rule 26 by filing the establishment paternity, quote, without medical evidence. Petitioner filed the underlying action for an improper purpose without medical evidence to support her claim. And Laura, I can feel I'm reading your mind. Everyone may not realize this. There is no requirement under the law that there be medical evidence to support your claim when you file a petition of paternity. You have to have a basis to think that you might be pregnant. Ugh. And you have to think that the person that you're naming as a respondent might be the dad. But the whole point of doing this is to get proof of who is the dad. And it's the simplest thing in the world, which I know because I have done it myself, because I've been through a paternity case. You take a test, it takes 5 minutes, and you're done. Do you all remember when he said earlobes is how he determined he was not the father of a child, the earlobes? And then he went and actually did take a test and he wasn't, but still remember that nonsense. That was good enough. So anyway, it does. I know it irks you to no end, Laura, and it does me too. For Woodnick to say that you are a bad person because you filed this case without medical evidence, which is not true. You didn't have DNA proof, and you didn't have a verified sonogram at that point. We'll get to that, but you had reason to believe that you were pregnant, and you had reason to believe Clayton was a dad. You hadn't been with any other men, right? So if you were pregnant, it had to be him. And you, I know you guys talked about that, and he said he admitted that, or I think he said in an email back to you, he said, if you're pregnant, it's mine. Yes. So anyway, Woodnick says you violated Rule 26 in the motion for sanctions filed after you had already moved to dismiss. Immediately following the Rule 26 motion, the record becomes a confusing and contradictory mess. To begin, on January 24th, 2024, the trial court issued an order granting Laura's motion to dismiss. There's a link to that order right here. There, in the dismissal order affirmed for a second time the next day, the court indicated, quote, petitioner advises she is no longer pregnant and has filed a motion to dismiss. While the court will grant the motion, the issue of sanctions and attorney's fees remain okay. Okay, fair enough. On February 2nd, 2024, the trial court issued a new order setting an evidentiary hearing regarding the issues of sanction fees for February 27th. Shortly before the original hearing date, which was later continued to June 10th on February 21st, 2024, the court issued a new order denying Laura's motion to dismiss, despite the fact that dismissal motion had previously been granted twice a month earlier. Bizarre matters then become even more convoluted and confusing. First, on April 3rd, 2024, Clayton moved to withdraw his motion, Rule 26 motion, after more than a month passed without any decision from the court. On that request, Laura filed a motion for judgment. On the pleadings, this is an appropriate place to stop and say, I don't think people understand why Clayton moved to withdraw the Rule 26 motion. He did that because I served Woodnick with a written demand that he withdraw it. We know, we read it. Everybody's read all of the things, David. Because he didn't follow the rules and there was no basis for what he was asking for because he hadn't followed the rules. And I told Woodnick, if you don't withdraw that Rule 26 motion, I'm going to move for sanctions under Rule 26 against you. And after I served him with the written notice, guess what? He did. He withdrew the motion. He withdrew it because he didn't want to be sanctioned by my opinion. I am not a mind reader, but by withdrawing his Rule 26 motion, he took the safe harbor that we're talking about. So I don't get sanctions against him for the Rule 26 motion because he withdrew it. That is why this case gets so screwy because his Rule 26 motion went away because I told him to take it away or I was going to get sanctions against him. And I didn't have an opportunity to do that because he did the right thing and dropped it. Dropped the sanctions motion. Okay, anyway, but so he moved to withdraw the sanctions motion more than a month went by, and the judge hadn't ruled on it. And that was a problem for us because we had a trial date approaching, and I did not know she could have refused to allow him to withdraw it. I didn't know. So I filed a motion for judgment on the pleadings, explaining that the motion that Woodnick filed, the Rule 26 motion couldn't be granted because he didn't follow the rule. So I filed a motion for judgment of the pleadings. That motion argued that because Clayton had failed to comply with the procedural requirements of Rule 26 sanctions, where unavailable under Rule 26 or any other authority, such as the court's inherent authority. The motion also renewed Laura's request to dismiss the action since there were no other issues for the court to resolve on May 16th, 2024. The court issued an order granting Clayton's request to withdraw his Rule 26 motion for sanctions. That order did not, however, resolve Laura's request for judgment on the pleadings, nor did the court mention Laura's renewed request to dismiss her petition about 2 weeks later on May 28th. The court issued yet another confusing order explaining that due to a clerical error, the court had intended to issue a ruling on Laura's motion for judgment on the pleadings, but due to this undescribed error, the court's decision was, quote, not remitted to the parties. The court discussed various arguments raised by each side on the question of whether Laura could still be sanctioned. given the Rule 26 motion was withdrawn and no other sanctions motions were pending. And explicitly, the court concluded that Laura's legal arguments regarding sanctions were, quote, moot. And therefore, the court said the record reflect the court declines to take further action. So, to recap, Aurora, I know you want lunch. To recap, at the end of May 2024, Clayton's Rule 26 motion was withdrawn. The court ruled the issue of sanctions was moot, and no other motions remain pending. Despite this posture, and with nothing left to decide, the court still held an evidentiary hearing on June 10th, 2024. Following a 2-hour hearing on June, it says 18th, but it's the 10th, 2024. Oh, no, wait, I'm sorry, hearing. On June 18th, 2024, the trial court issued a lengthy 19-page decision which contained findings on the issues of sanctions, paternity, attorney fees, and costs. Many of these findings are either directly contrary to the admitted evidence or supported by no evidence of any kind. In the end, the court found Laura acted unreasonably when she initiated action without basis or merit, without an authentic sonogram, ultrasound sonogram, physical examination, and in conjunction with the belief she passed tissue in July 2023, the court finds the underlying petition premature at best in the post-trial ruling. The court again recognized Laura's argument that Rule 26 sanctions were inapplicable because Clayton failed to comply with the procedural requirements of Rule 26. The court further noted a separate problem. Clayton's Rule 26 motion was withdrawn. Quoting from the judge's ruling, quote, the question thus becomes, can the court still award Rule 26 sanctions considering respondent's withdrawal of his motion without allowing any input from the parties? The court held despite the withdrawal of Clayton's motion and ignoring his failure to comply with the requirements of Rule 26 and contrary to its prior order, holding the issue of sanctions was moot, and despite the fact, oh my God, this is so exhausting, the case had previously been dismissed twice, sanctions could still be awarded upon sua sponte, is what that's trying to say. Means on the judge's own initiative. It means not because a party filed a motion. It means because the judge on her own, welcome back, decided to do this. So the judge wrote, sorry that you have been. Everybody's getting gold stars today. This gives credence to the idea that the family court's inherent authority to award sanctions under Rule 26 should not be read to be limited by the course of the case, or that by the litigation strategy pursued by the parties, the power is there by rule and can be used by the court when necessary and appropriate. In addition to awarding sanctions sua sponte under Rule 26, the court also concluded Laura knowingly presented a false claim, knowingly violated court order compelling disclosure or discovery, so on and so forth. The court later awarded Clayton fees and costs in the amount of $149,000. Post-trial developments before the final judgment awarding fees and costs was entered. Several critical events occurred. These developments warrant further discussion as they relate directly to the legal arguments presented in the appeal. First, immediately after, Laura has not talked at all. She said what, 2 sentences in this whole thing.
Her eyes are probably crossed.
Probably. She's just probably like,
I know mine are.
And then amazing, because I don't have ChatGPT to tell me what he's actually talking about because I don't know.
No, he doesn't even know what he's talking about.
He doesn't even know it. That's fair. Trial ended on June 10th, and we learned several individuals posted videos on social media claiming the trial judge's father, Mr. Harry, how personally attended the trial and allegedly spoke with him about the case, among other things. These supporters claim Mr. Harry had told them, he discussed the case with his daughter, Judge Julie Mata, and that she printed out case-related documents for him and said inter alia that means, among other things, Dad came here. You have got to see this second and far more concerning after receiving the court's post-trial ruling. Laura immediately noticed. Oh, so the transcript's calling her Lord instead of Laura. Dear God, help us all. Laura immediately noticed one of the most critical factual findings was not based on any evidence submitted at trial. Rather, the key finding appeared to have been copied from a social media post made by an anonymous third party after the trial concluded. Specifically, in summarizing the trial testimony of Clayton's medical expert, Dr. Samantha Deans, the court made the following findings. She, Dr. Deans, testified that Planned Parenthood is not open on Sundays. The specific finding that Planned Parenthood is not open on Sundays was attributed to the trial testimony of Dr. Deans, but as the trial transcript clearly shows, Dr. Dean said no such thing. Instead, it appears the only basis for the court's finding was social media posts published online after the trial concluded. Immediately upon discovering this extremely serious misconduct by the trial judge, Laura filed several pleadings, including a notice of change of judge for cause supported by an extensive affidavit of counsel. Laura also moved to vacate the judgment, moved for a new trial, moved to alter amendments simultaneously. Laura, meaning me, also reported these matters to the Commission on Judicial Conduct, which opened an investigation, which remains ongoing as of the date this brief was filed. And that is still ongoing, in my knowledge, on July 18th, despite having no authority to do so, while she was subject to a pending notice of change of judge, and before Clayton filed any brief opposing the motion, Judge Mata denied Laura's new trial motion and her request for other relief several days later after the apparent act of retaliation was reported to the Judicial Conduct Commission as a violation of Commission Rule 14, which prohibits acts of retaliation by a judge in response to a complaint. Judge Mata issued a new order withdrawing her prior order, claiming she was unaware of the notice of change of judge. That would suspend her authority, even though the notice of change of judge was mentioned on the very first page of the new trial motion that she denied. So she either didn't read it or she did read it and then just was not honest about this. I don't know. That's not a fact on August 13th. The presiding family court judge, Rhonda Fisk, denied Laura's notice of change of judge. In her order, Judge Fisk recognized, quote, Laura correctly points out that Judge Mata's July 17th, that's a typo in Fisk thing, contains a factual error. The transcript from June 10th hearing shows Dr. Samantha Deans did not testify that Planned Parenthood is not open on Sunday. Despite this, Judge Fisk concluded the evidence failed to show Judge Mata independently investigated the facts. Quote, the court finds Laura relies on mere speculation and suspicion when alleging that Judge Mata engaged in a secret, undisclosed investigation and is therefore biased. I have a new theory on this, and I'm not going to stop and tell it now, but I have some thoughts on this issue that I want to share. I'll do a video later. We got to get through this. Aurora is starving to death. Despite the
Just gonna
judge,
let my cat die, but I'm gonna say what I gotta say for at least 10 more pages.
Mhm. Despite this, Judge Fisk could not explain and did not explain how Judge Mata could have properly found that Planned Parenthood is closed on Sundays. Since no trial testimony or evidence addressed the issue, Judge Fisk ultimately brushed that concern aside, concluding the question of Planned Parenthood's business hours is of little to no importance, given the rest of the findings from the July 17th, should be July 17th ruling. After Judge Fisk denied Laura's notice of change of judge, she authorized Judge Mata to rule on any remaining issues, thus resulted in the court's granting of fees to Clayton and denying all of Laura's motions. This appeal followed court has jurisdiction. So I'm going to read this and then we're going to stop. So there are 5 arguments on appeal. Issue number 1, as a matter of fact, a matter of first impression. First impression means that there's no public published or controlling authority out there on this. I don't believe there is in Arizona because nothing so weird has ever happened As a matter of first impression, when a party files a motion seeking sanctions for an alleged violation of Family Rule 26, but that party does not comply with any of the procedural requirements of the rule and later withdraws the motion, may the trial court nevertheless award Rule 26 sanctions sua sponte in a manner that wholly ignores the procedural and safe harbor requirements of that rule, and assuming sanctions were unavailable under Rule 26. Did the trial court err by sanctioning Laura for a Rule 26 violation using its inherent authority or other law? That's issue number one. And the relief requested under issue number one is that I'm asking the Court of Appeals to reverse Mata's judgment in full. Basically, send the case back to her with what's called a mandate. It's asking for instructions that the Court of Appeals will tell Mata, basically order her. The case is dismissed because on December 28th of last year, Laura moved to dismiss and was entitled to dismiss, and Judge Mata erred. She didn't allow that to happen. She should have done so. And what we're asking the Court of Appeals to do is basically send us back to December 28th. The case will be dismissed here. There will be no fees for Clayton. There will be no findings against Laura. It's interesting because I don't even know what that would do to Rachel Mitchell. I hadn't thought that far ahead because Rachel Mitchell is looking at you. Rachel Mitchell, by the way, side note, is the district attorney for Maricopa County. She's investigating and ended up charging Laura with 14 felony counts. So there's that. Which hadn't thought that far ahead because Rachel Mitchell is looking at you because Judge Mata referred you to her. But that referral board of appeals, I mean, it could take that away. It's interesting. I don't know. Conversation for another day. Issue number two. Did the trial judge commit structural error, entitling Laura to a new trial by conducting an independent investigation? That's the Planned Parenthood thing. Issue number three. Did the trial court err by awarding sanctions under other laws when there was no basis for such an award and no motion for sanctions was ever filed under those other things? That's issue number three. Issue number four, did the trial court err by awarding legal fees of $150,000? The alleged misconduct did not cause those fees to be incurred. That has to do with the timing because from August 1st, 2023, until Woodnick showed up, by which point you were no longer pregnant and weren't claiming to be anyway, there were no fees in that period because Clayton didn't have a lawyer. Neither did you. So the fees were after the fact. So the question is, could the judge tag you with those when the misconduct stopped? By the before those fees occurred, the alleged misconduct. And issue number five is, does Laura get her fees? Is Clayton going to have the play? Laura. So that is pay Laura. So that is I think that's a fair summary of where we are in terms of the technical arguments that I'm making. They would put 99% of you to sleep, and other 1% of you are on drugs. What? What are you even saying? Okay. Nobody wants to hear the legal arguments right now. It's too technical. You're not going to understand them, idiots. I will explain them to the Court of Appeals and they will understand it perfectly. I said in another video, my belief is that the Court of Appeals is going to, I use the word crucify, and I mean that as a figure of speech. I didn't mean that literally, nail her to a cross. They're going to be very unhappy with Judge Mata, I think. And the reason that I think that is because this is not about Judge Mata. It's not about Clayton. This is not about Laura. For those of us who care about the legal system, I need the public to trust our court system, not to think that it's a joke. And the way that Judge Mata handled this case, I think was a joke. I think she treated it like a joke, and I think the Court of Appeals is going to be very angry. And they should be when they see a member of the judiciary making everyone look bad in the profession. So that's my take on it. Clayton, you're gonna have your, you know, Clayton's counsel will have their opportunity to respond to this. They obviously disagree with my arguments, although not that strongly, because when I told Woodnick I was going to ask for sanctions against him, he did not stand up and fight. Although he thumped his chest and said, Gingras, you're wrong. Gingras, you're an idiot. He caved. And I'm glad that he did. But that shouldn't have been the end of it, or that should have been the end of it, and it wasn't. So now we're here. So Laura, I forgot you're even here. He didn't say that, but I feel like he meant that. Do you have any questions before we go? Aurora is going to kill me if I don't feed her. No questions. I think. Oh, I'm sorry. No questions. I think you explained it really well. Um, in the first 15 pages, and I think we've gotten to go over it, and you answered my questions. Okay, but I'm sure other people's too, if they have them. Yeah, I know. Um, oh, I think it's him now. Yeah, I know I did. When I first read it, since I have you here, can I ask you, do you want to and I still want you to do at some point when you're ready, a live debate with maybe that's too much, but I'd like Aurora's knocking things over. I'd like you to at least answer some questions. I'm going to read you one. This is the same question I asked you this before. This is a question that was a DM to me by a nice young lady named Ava. And she said she had a question for you. My question to Laura, are you okay? And how are you currently doing? What does the future look like for you? And what are your plans and goals moving forward? And before you answer that, I have had pleasant conversations with a large, no, not that large of a number, but with multiple JFC or Clayton leaning, Clayton supporting people. I've had quite a few messages, text messages. I've had phone calls. I've talked on the phone for an hour with the person who hated you, Laura, and actually still doesn't like you and still doesn't believe you. Why would you say
First off, is
Idiot.
Ava real? I doubt it.
Yikes. But way to
I
let you know.
cannot believe that he actually talks to people on the phone.
I know, right? And still doesn't believe you. But that person who we're not going to name, but you know who I'm talking about. That person has told me that anyone well, she that the person has said that they agree with me about Judge Mata, that they think that what Judge Mata did here is wrong. The person doesn't like you, doesn't believe you, doesn't think you were pregnant, Laura, but doesn't like the process that was followed here. And that's I wasn't there that night. I don't know what happened. You do. Clayton does. And that's it. And I honestly, it bothers me to no end to have people like Dave Neal or whoever sit and say, tonsil twins. You couldn't have been pregnant terms, and nobody knows what happened, like you said, except for me and for Clayton. And like the gall of people to think that they can go and say this didn't happen that night. It was only oral sex. Like that is why Dave Neal, I have a real problem with him. I don't have a problem with people covering this case, and I don't have a problem with people talking about it, being interested in it, but you are not in the room. And Laura, I would never say to anybody that why would I say that I have any idea what happened here? I know what the facts look like to me, and I am going to do a video in the next few days. I'm incredibly busy, excuse me, and we have holidays coming up, and I've got family coming in. I'm going to do a video explaining my arguments, why I believe that you were pregnant, because everyone says she was never pregnant. but you know it. And you know it, Gingras, and you're a liar, and you're unethical. For no, I believe you, Laura, and I have not had a full chance to make my arguments to the public because what we had as a trial was a joke. Um, I'm going to do a video and I'm going to make those arguments, and the people on the other side can do their own video and they can respond. And the difference is between me and Dave Neal, I'm not going to sit here and tell you things that are false, like, oh, HCG tests, those are those don't count for anything. They're not real. Yeah, nobody should have a reaction if they have a positive home pregnancy test. They should just go about their day, right? Well, let alone lab tests. Okay, we're gonna get to all that, but for now, that question: do you want me to read it again? Do you want to? Do you want that from? I know what is it? How are you doing? You okay? Yeah. So I answered this the other day. Oh, this is her. Yeah. So I answered this the other day when we were in the studio, and I think I can answer it in an even better way. At this point, I think under no circumstances am I okay. I think that the fact that when you and I recorded that 2-minute video at the studio, that I saw so many comments from people saying like, "Oh, she's smiling. She's fine. Like she's okay." I feel like for JFC, I am so self-conscious of how I look on camera, of how my face looks, of how whether I smile or not. And I know everything's going to get turned into a meme. So that just really shows how little JFC gets it. And no, it just shows what a what a sick group of really sad people they are. I mean, again, I don't care if you support Clayton. I don't care. Oh, this must be him now. All right, whatever. We'll switch to him, I guess. I don't care if you don't support Laura, but to disrespect another human being in the way and to do it with joy, it's the cruelty and malice that I've seen. It's freaking sad. And I mean, I guess maybe this is just, what human beings are. We're all like wolves, fighting over a carcass or whatever. And we try to be civilized and respectful, and some people just aren't. And, Laura, I think you and I have some sort of an understanding that I try to be a nice person. I've known you for what, 8 months now? Um, I knew you when I first met you. Because of what Wood said about you, I was really concerned that you were insane, that I couldn't be alone in a room with you because I was going to be the next
Oh,
accused
wow.
victim. Wow, indeed. Uh, all of these things that Woodnick drilled into my head during our first conversation, not one part of that has been borne out as accurate. Nothing. I mean, I have talked to you more than any other client this year. That's an easy one.
Hmm.
We've spent hours and hours and hours communicating and getting to know each other, and I agree with your autism thing. I feel like I feel like,
I've spent a
it's
lot of time with you, and you are definitely autistic.
is that you should be a relief that there's, some possible kind of, because you're a little different. God. Oh my God.
I told you, he throws shade at her so much.
And he's saying this to her face.
I know. But she's autistic. She won't understand what he's saying.
Fine. Because you're a little different, you're a little different. I said that.
Oh,
You're a little different.
there's something wrong with her.
I think you suffer from having an unbelievably high IQ. I think you're very, very bright girl. And I think you're just a little different. And I'm a little different. I'm a little different. I think you are one of the most misunderstood people I've ever. Well, I know from the because and again, I take some, guilt from the fact that our PR campaign has been nothing and you're fighting a PR war against at least half a dozen YouTubers making videos every single day and spewing bile lies, half truths and it works it's that it works. They're doing it because it works. If you paint somebody as crazy long enough and the public doesn't know, people watching this doesn't know you, if all they knew was what they heard Dave Neal say, I would be scared of you. I was scared of you until I got to know you. And we should I don't have enough time in the day to. I'm a full-time practicing lawyer. You are not my only client, and I can't put the time and effort into this that Clayton is putting in, or that his crew or cult is putting in. But I think we need to have the public get to know you a little bit better. We need to do this a bit more often, and try to take some control back. Of the narrative. And that's what is the weirdest thing about JFC. They are so angry when you fight back against their narrative. They will not tolerate anything that interrupts their narrative. And it's weird. Why are you so angry, guys? Why are you so afraid? Why are they so angry? And saying that, like, even with autism, like, I'm trying to weaponize. Oh, this is her now. Oh, let me get into her. I don't know where this picks up between the two of them because it really could be either of them, but I guess it's her. Um, why are you guys so angry? Why are you so afraid? Why are they so angry? And saying that, like, even with autism, like, I'm trying to weaponize that. And I'm doing a disservice to everybody who's been autistic or with domestic violence. Like, none of it happened with Mike or Greg or with Clayton. None of it happened. Okay, stop. This must be him. Okay, stop. We're going to get into that. We're gonna get into that. But from what I have seen, knowing you and look, people, I've been your sort of spokesperson, I guess, for the last little bit. And people could take out their fury on me and think I'm such a scumbag. I can't tell you how many messages I get on Twitter, which I am going to leave that site soon. Because just Elon, just anyway, I get all of these messages from people that are like, these short little tweets, how dare you represent her? She's lying, blah, blah, blah. These people have never spoken to you in their lives. They don't know you at all. They feel entitled to judge you based on what a stand-up comedian who's never met you says about you. And these guys with an axe to grind, an ex-boyfriend, an angry ex-boyfriend, the fact that people think it's okay to judge another human being with such limited information. When I spent how many hours, I actually have written down how many hours because I used to put it on your bill because I wasn't charging you for phone calls, but I wanted to keep track of the time. I've spent hundreds of hours talking to you, hundreds. Yes. I know you. I'm not saying I know you, like a lifelong friend. It's been 8 months, but it's been a very, very, very intense 8 months. And your behavior and what I've seen from you and with you is absolutely 180 degrees different from the story that Dave Neal and the other very, very disturbed JFC cult leaders the narrative that they're putting out about this person. If you were a member of the public and if you got time to talk to Laura and get to know her, I have. You would want Dave Neal in jail, straight to jail. He should go to jail. Um, oh, you would say that there is no way that any rational human being could tolerate that Dave Neal has done to you. What's he put you through? And again, it's I think a perfect example is Alex Jones. Oh no, are you kidding me? Get out of here. Alex Jones, the Infowars guy, who decided that a school shooting in Connecticut never happened. He just made that up. And he tortured the families of 26 murdered school kids and got it's very, very analogous to your situation.
Is
And
it?
and people believed Alex Jones. They believed him until he was dragged into court and ordered to pay the number was I think $1.5 billion in damages. And he's at loss. He's losing everything he owns. There was on the news about this. The Onion bought Alex Jones' website. So Alex Jones is now going to be offline. He is going to be unhoused. He is going to be bankrupt for the rest of his life because he
No,
did to the families of murdered children what Dave Neal is doing to you. Shut up. Those are not at all the same things.
I
Stop the games.
am. Wow.
Wild. Murdered children, Dave's and if people don't understand that yet, I think that's why, I feel like there's another chapter to come out of this. And Dave, you know, I know you're confident in your side of things. You think you're so righteous and you have so many facts on your side. Alex Jones said this exact same thing. And you know that story didn't work out very well for him. And I told you this in my very first email to you. I wasn't threatening to unhouse you. I was trying to tell you and ask you to politely to be careful. I said, "Be careful. Tell both sides of the story." That's what journalists do. You are not a journalist at all. And that's fine. Whatever. It's fine to be a commentator. That's not illegal. But a commentator who does what you have done to Laura, you and Alex Jones are cut from the same cloth. And that sucks because you're a dad now. Your kid is going to have to look to look up to you in the future one day and say, "Daddy, were you a good person?" And the answer is no. Wow, David, this is kind of a low blow here, buddy. This is not tasteful
Wow, he
at all.
brought his kids into it. Well, that maybe explains why Dave was like
Hmm.
not too
Hmm.
keen on accepting
Yeah,
his apology.
yeah. And that's going to suck for you when you get to be old enough that your kid goes to school with other parents and they start finding out what you did to Laura. That's I got a story about that. Anyway,
Of
it's
course you do.
Sunday. Let's not get fired up or Aurora needs her lunch. And this is not they get so mad when they feel threatened. I'm not. This is not about threatening. This is about do the right thing. Okay? If you're going to tell a story, tell both sides of it and tell it in a neutral, dispassionate, being like what you see on the news. Okay? Have you
But
watched
he's
the
not.
news? Get out of here, David.
But he's not even a news anchor. If you want the
No.
news, go watch a talking like if you want it's my channel. I'm going to say what I want,
And
right?
as we know, they're not reliable. Exactly. You tell both sides. You don't pass judgment. If you get in bed with one side of the other and you say Clayton's right, I know he's right. What if he turns out to be wrong? Uh, you know, that the day is still out. There's so anyway, Laura, anything else you want to add before we cut this off? No, I think we should do another episode and I'd love to join you on the podcast Last show that you're starting. First of all, this is a show about hungry animals. Um, oh, I think this is back to him. You're starting first. First of all, this is a show about hungry animals. So we could do a horse show. Should we do a horse show? We could definitely do that. People would meet Laura at a little is Nugget a rescue? Nugget is not a rescue. His little buddy Crackers next door to him is but oh yeah, okay. So Laura has a horse that is the size of a large dog named Nugget. And it's Nuggets, very cute, kind of like Aurora is cute. Okay. Listen, this is all right. This is too long. I gotta stop. It's Sunday. I got stuff to do. Thank you for your time, Laura. Thank you for anybody watching this. And I mean what I say. As far as I want both sides of the story to be out there, and I don't want people to be mad at anybody you shouldn't be mad at. Laura, look, obviously, if you lied and made the whole thing up, you deserve some punishment. I've said that all along that if I if that's what I if that's what the facts bear out, I'm not going to stand by your side. I'm not here to defend people that do stuff like that. But I haven't seen anything to support it. And in any case, even if you did fake it with Clayton, I don't accept that $150,000 in fees is the right outcome. It just isn't because I do this for a living. I've had lots and lots of cases where people have lied. I've seen people lie on the other side of cases. I've never seen anybody sanctioned. I mean, very rarely, and never in this to this degree. I mean, anyway, another episode for another day. Okay, guys, thank you so much for stopping by the David, Laura, and Aurora show. If you want to use 5-minute clips of this, you don't go ahead. Use 5-minute clips. 1 5-minute clip is fine. You take the whole thing. I'm gonna copyright strike you. Just let's don't do that, okay? We will do this again soon. I'll post some links to things and we'll talk later. Thanks. Bye. Now, he wants the whole story told on both sides, but then he's like, don't use my things. Don't use all of my things. All right. By the way, you have such a new channel that you don't even get monetized for anything. Like, stop. Stop. Oh my God. All right. So we got time for
That
some more.
that was ridiculous. And what clips are you taking from that? You spent the whole time reading your damn appeal,
Right?
and not saying anything else other than she's like out like getting harassed, like Alex Jones harasses the parents of Sandy Hook.
Which
Like
is crazy.
there was, oh my gosh.
Crazy
Well,
pants.
Laura did try that, right? She did try the copyright strike thing and didn't realize there were other steps involved after
Yeah.
that.
Yeah.
So
You got to take us to federal court, babe. Still ready. I got time. Apparently, I sit here all day and do nothing. So, there's that. All right. So next on our list is a shorter one. We're not getting through all these today, but I had no idea how long these were going to take anyway. So you want to pull up November 19th, entitled David Gingras responds to Omar Serrato regarding Laura Owens and Clayton Echard. Omar. Okay.
yeah, that's the 11/19 one. I already had that pulled up.
Okay. I'm going to go take a quick potty break. Because boy, that was long.
Yeah.
It's going to take us longer to wrap these up than I thought they.
Is it showing up good? Okay.
Yeah, that's fine. All right, I'll be right back. While you
All right. See, he starts it all out the same way. Good afternoon, everyone. Today is Tuesday, the 19th of November. I'm looking at the wrong screen. Hey, that's me. Every time I stream, I don't know where I'm supposed to be looking. I am David Gingras. I'm not a podcaster. I'm not a YouTuber, and I don't have a name for anything, but I do have some comments. Just really briefly want to share I actually did a much longer video earlier today talking about Mike Maricini, and after thinking about it, I decided, you know what? I'm gonna put that one on ice for a minute. I don't even care to explain why. Today's video, this little short thing is going to be about Omar. I saw last night, I was cooking chicken fajitas, as you do. Oh, and I have a new microphone, by the way. Do I sound better? Should I try and talk like Barry White? Like, hey, that's really creepy and weird. And I saw some Omar, podcasting, whatever he was doing, streaming something about me trolling JFC. And hey, I don't care. I don't care. I don't have time to watch all of these things, but I just happened to randomly see a little piece of it where he was citing case law, reading, giving actual case name citations, and then talking about the fact that he felt I was just not a family law attorney. And therefore, I was going to lose because I didn't understand how the law, I didn't understand the law. And he was quoting and reading some statutes in Arizona, which again, no disrespect at all to Omar. He's not licensed to practice law in Arizona. He is entitled to sit and read whatever he wants to on YouTube. That is not practicing law. So he's okay.
What could Omar possibly know about the law in Arizona? What? Okay.
It's okay. But he can read it if he wants to. That is not practicing law, so he's okay. But I am licensed to practice law in Arizona and in California. And I am not a family law attorney, but this stuff is not that complicated. It just isn't. And I don't know why. I don't know why Omar seems like he's deliberately avoiding getting to the truth. Because if you want to know the truth, I've offered, just pick me, pick up the phone, call me. I've talked to him. We've had a pleasant conversation. I'm not threatening him. He says that all the time. Every time he talks to somebody, he's like, I'm not threatening them. I'm not threatening him. And, I have no intention of doing that. I'm just trying to get the truth out. It seems like Omar is doing something different. Anyway, there's just one little point that he made in his video that I'm going to talk about, and then I'm going to go out on my walk. I do 4.5. I do 5.5, 4.5.
Oh.
I do 5.5 miles a day.
Wow.
Trying to get in shape because, he was looking chubby on his last stream.
His words.
Not ours. Yeah, so I'm trying to get into shape. Omar tried to explain all of this family law is a little different, and Gingras doesn't know family law, and that's because he's, not a family law guy. I think that should be a new cartoon, Family Law Guy, like the Family Guy, but like the
Yes. Family law guy.
Yeah, that'd be cute. And Omar found a law and he read it and he thought it was really compelling. It's ARS 25-324. It's up on the screen right over here. And you can just read it yourself. He read the whole thing. And he said, well, this really seems like, this is right on the petition was filed and not in good faith and for an improper purpose. And oh boy, this is Clayton. This is what Laura did right here. Wow, Gingras, you idiot. How'd you screw that up? If Omar again, and I mean this in a friendly way, man. I'm not trying to troll you. If Omar was licensed to practice law in Arizona, he would know how our statutes are set up out here. We have ARS Title 25. It's a family code, and if you read this, the fees that are available under this statute are for maintaining or defending any proceeding under this chapter or chapter 4, article 1 of this title. This chapter is chapter 3. Okay, that is dissolution of marriage. So when you are talking about attorney fees under ARS 25-324, this chapter 3, dissolution of marriage, was the Owens versus Echard case, a dissolution of marriage case. No, it was not. RS 32, I don't know what he's saying, also allows fees if the case arose under chapter 4, article 1. Chapter 4 has to do with legal decision making and parenting time. That is not a paternity establishment the court could have reached. That if there was a child born, but that's not what Laura filed. She filed under this chapter 6 paternity and paternity proceedings. That's what ARS 2581 is. The paternity, these are the statutes that deal with the maternity and paternity proceedings. Now, if you were licensed to practice law in Arizona, you would know that AR 25324 deals with divorce. And this parenting time thing, she does not deal with this. Parenting time thing does not deal with maternity and paternity proceedings. So, I appreciate Omar's effort to find any possible little crack in my argument and say, oh my God, Gingras doesn't know what he's talking about. I am definitely not the smartest, sharpest tool in the shed, never claimed to be, but he passed the bar exam twice on the first try.
That's right.
But I am licensed to practice law in this state and have been for over 20 years, and I can read our statutes and understand them. And unfortunately, Omar, man, you're wrong. All right. I've pointed this out. I've pointed this out in other pleadings. And I know you don't read every word of every page of every pleading, but we do. And that's fine. I'm not asking you to, but you shouldn't express opinions about things that you don't understand and that you haven't spent the time studying.
Wow.
I took the bar exam out here, man. I took the California bar and then I took the Arizona.
Which I hear that California is very hard.
I'm sorry. Because the fact that I just mentioned this like 3 minutes ago and he is definitely going to bring it up here is actually
absolutely. He wants you to know.
Perfect. I took the time studying. I took the bar exam out here, man. I took the California bar and then I took the Arizona bar and I passed them both my first try. And I worked in law firms for decades. I mean, over 10 years between the two firms I started at. At the first firm, I did almost only family law. That was pretty much all we did. One of the lawyers there, they did nothing but family law. And anyway, look, it's neither here, there, nor there. What are you drinking, sir? I'm going to get out and I'm going to go on my walk. All I'm trying to tell you is, and by the way, I'll save you the trouble, Omar, fees are not available under 25324. There's a different statute that does permit fees under a similar kind of theory, but it just goes to show you need to be careful. And not jump to conclusions. And that's why I don't like when people like Omar go out and do these podcasts and then basically proclaim, I got you, I win. Clayton wins. Gingras is an idiot. It's not that simple. And a better way to do this would be to hear from both sides, this is why I've offered to talk to people, to try to explain my position so that you hear my side of it. And not just the pro Clayton side, which may not be correct, because I still haven't heard a single Arizona licensed attorney talking about why I'm wrong. I haven't seen that. If they're out there, they're being very quiet.
Why is that? I wonder.
Obviously, Woodnick in Arizona, a licensed attorney, he thinks I'm wrong. So let's just wait and see what Woodnick says in the Court of Appeals. And I made this argument. It's in my brief regarding ARS 25324. And again, there's a different statute. It doesn't have the same wording as this, but it's a similar idea. And as for the other arguments that Omar made in his show last night, I didn't catch the whole thing, but what I did see, I did not agree with.
You absolutely did watch the whole thing. Stop.
Oh, he
Stop
did.
the game.
He did.
Absolutely did.
Oh, Lord. I did not agree with, for a lot of different reasons. And again, I think Omar has an agenda. I think he is advocating that agenda as best as he can. There's nothing illegal about that. It's like he's trying to convince himself not to be mad. There's nothing illegal about that.
I don't like it. I don't like it at all. Me.
But
he doesn't know what he's talking about.
Yeah, but he's like trying to soothe himself. There's nothing wrong with what he's doing. It's okay. He's allowed to do this, just like you're allowed to. But Gingras, you could do this too.
You can do it.
There's nothing illegal about that, but I think the Court of Appeals is going to see things differently. I hope they do anyway. I'm going to keep it short. I have a good Tuesday. This week is going to be weird. I'm going to have family coming in. I've got a lot of things going on. I'm going to try not to podcast or whatever you want to call this. I just got better things to do. I got a disclosure statement in another case with 800 pages of crap I got to look at. Anyway, have a good week. I'll be around if anybody needs me.
Oh, okay. Okay.
If you need me.
Okay.
You know where to find me. I'll talk to you later. Thanks. Bye. Thanks. Bye.
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 Surprised he didn't drop his phone number.
You can call me at. All right.
Well, I think that's where we're just going to stop today because I can't take anymore. If we go further, I'm afraid my brain is not going to function later today.
I thought he'd be more fun.
Well, who knows? There's still plenty more. There's a whole lot more to cover.
I think there was like 14, right?
But there's so many. And we only got through like half of the ones I had scheduled today because I didn't know how long it was going to take. I mean, I know that it said like in the transcripts, the timestamp, but that doesn't mean anything, right? You could.
Oh, no, it does.
There could be silence though for like 5 minutes and it's still going to like show like 10 minutes later. You know what I mean? So I was like,
that
okay.
It's in silence. I
Nope.
think silence bothers the crap out of him. That's why he doesn't shut up.
I was gravely mistaken. Good thing I'm doing a bunch of planning this week because my planning was certainly off tremendously. So I think that's where we're going to end today. He's something. I wish we would have been around. We would have had so much fun.
Mm-hmm.
We would have had so much
I would
fun
have saved those videos. I would have downloaded them and saved them.
Who knew? Was it a smart decision in his part? I don't think so. How confidently incorrect he is about the future is so. I think that's one thing by covering this case is everybody's predictions from that side have been wildly wrong. There's so much foreshadowing that they don't even realize that they're foreshadowing the outcomes here.
Yeah.
But I enjoyed it. So that is where we're going to leave off today.
I thought
Uh,
it would be as funny as his blogs, but he's like, he trips over himself a lot. But I guess that's the difference between being able to write and being able to talk. I feel that.
That's true. I mean, I will say that for those that like don't do this, it is very different if I'm doing a live versus recording a video.
Mhm.
I mean, I can record a video without anybody around, but it's weird. It is weird.
Mhm.
And normally I will have somebody come in with me just so I get like the same vibe and energy as when we're live, right? Like I know you all are there in the chat when I'm live, but when I'm just recording something where there's no one, it's weird. It is very weird at first. You get
See, and I
used to
feel
it,
like
but
I'm the opposite. I can sit down and record something and play it up. But when as soon as I know there are people watching me, like sometimes I have to hide the chat because I'm
yeah.
like, okay, you're censoring yourself too much. You're being very, very
Mm,
like hide the chat and pretend it's just if it was just me and Llama, I would be saying a whole lot more.
it's true.
And it would be a lot more. But and I'm like, stop it. I know they're not there. They're not there.
It's true. We are kind of opposites in that because I feel like, I don't know, recording things like you're way better about it than I am. Especially, we've had these conversations of like making shorts and videos, and I'm like, I don't even know what to talk about. I don't even know how to do that. What are you talking? Like, I can't break things down into 30 seconds. You know how long I stream for? It's because I am not capable of putting things in a small. That's not me.
It's
How
only
do I
3 minutes.
do that? I
Shorts
know,
can be 3
but
minutes long, but nobody's gonna
I
watch you for longer than 30. So
But it is very different, live recording, though, believe it or not, it is. It doesn't seem like it should be, but I know I'm not the only one that thinks that. You're not the I mean, we know other creators, it's the same. Recording is a bit, different. Like, sometimes I feel like I come across as too, uh, n mm, not as relatable maybe when I record videos and things like that. Like, it's a little bit more polished, which, I mean, is good, but it's very different, experience between the 2. So, but again, I've spent way more hours live streaming than I have recording things, so maybe that would have gotten better if I did it more often, but honestly, I just prefer live streaming things when I can. So, but that is what we've got for you today. Now, this weekend, I'm doing a bunch of planning for the next several months of what we're going to cover. When we'll definitely have Laura Owens next Friday. Will we have more than that? I don't know. We'll have to see. If you haven't, please go over and subscribe to the Couch Court with Llama channel. We are covering other stuff on that channel specifically, including Karen Reed's civil trials. We'll be wrapping up O'Keefe v. Karen Reed and catching up on that next week. And then we'll be diving into the Higgins Albert McCabe versus Reed and Turtle Boy, where we're going to be rewatching a lot of the testimony from Karen Reed's criminal trials. So if you've never watched it, and don't worry, there are plenty who watch with us who never watched any of that. Please join over there. We're doing that a lot. We're going to have, rewatches. It's going to be a fun time. Whew, it's you want to watch some wild ass testimony on the stand. It's all there. It's one of the craziest things and I can't wait to rewatch it again. And that's how you know it's good because to sit and rewatch trials and testimonies, that's how you know it's something because nobody wants to do that. But it's so what does Alessi say? What could be more egregious? What?
oh well.
And it's exactly that. So anyway,
What
I
could
hope
be more egregious? What could be more misleading?
exactly. Oh, Alessi. We somehow have to watch all of trial 1's and 2's testimony just so we get Alessi because he is my favorite attorney of all time.
I do love the nerd.
Yes, I love how nerdy he is. I love how passionate he is. I love that he knows what he's talking about, which is not, as I've said before in previous streams, lawyers, they kind of have to be like a jack of all trades to be a lawyer. Right? They're not an expert in all of these expert fields, but in order to give good representation, they have to like educate themselves about what they're talking about. And when you're the only one on, you don't always have time to do that. They're literally doing the best they can. But what I love about Alessi is that when it came, he was given all of the technical, forensic stuff, and it masterclass. Like really, it's impeccable to watch, and he doesn't talk down. He is smart, very smart, perhaps maybe smarter than a lot of people in there, but he doesn't show it that way. It's not pompous. It's as if he was your teacher,
Mhm.
and I love it. Anyway, I love Alessi. I remember when the trial first started, you were like, "He's gonna be your favorite Llama. You are gonna be, like, madly in love with him," and I am. Turns out, yes, I am. He's my favorite ever. So if you don't know anything about that, we got a playlist over there. You can watch as we've been trying to catch up because there are 4 civil trials. We will be wrapping up and being fully caught up on O'Keefe v. Reed next week, and then we're starting the Ham v. Reed Turtle Boy. I am so excited about it because I don't really know anything about Turtle Boy and this case. I know this
Oh.
much on what is a mountain, iceberg, if you will. So I'm very excited because, this is one of those stories and cases where there's always more to learn. Like you don't know, it's so convoluted and it's so much. So I am very excited to get in on all of that. So, all right, everybody. Well, we're gonna go. We hope you have the best Fukong Friday and have a great weekend. We will be back next week. Anything you want to say, Buff, before we go? You're muted.
No.
No, you're not muted. You just weren't saying words.
No, I
So-
just wasn't saying words.
No, I would like those hours of my time back and my brain
Oh,
cells.
I would like
back.
the brain cells
Yeah.
back. That's what I would like.
Alessi is great, Dean. I can't wait for you to come join us and talk about it. We'll let you know soon once I get all my planning underway, but I can't wait. All right, friends. Well, as I always say, until next time, go forth and be amazing. All right. All right. Bye, friends.